ಸೋಮವಾರ ಬರಲ್ಲ ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆ 1:30 2 ನೀವು Eviction notice was issued by the Tahsildar. He is from tomorrow.
Tomorrow.
The respondents have been illegally parking the vehicles in the petitioner's alley. Kindly take up the matter.
Next matter.
Whole matter. Kindly take up it on
Chair.
2022.
Wait. Other members you can give. It will come up. Tomorrow.
Your Honor, the respondents are trying to form a layout of the petition. They are doing rigorous attempts, Your Honor. Kindly have it tomorrow.
Next matter.
Please, Your Honor.
ಕೊಡಿ ನಾಳೆ ಫ್ರೈಡೆ ಜಾಸ್ತಿ ಮ್ಯಾಟರ್ಸ್ ಇದ್ರೆ ರೀಚೇ ಆಗಲ್ಲ, ಅದ್ರ ಬದಲು ಸೋಮವಾರ ತಗೊಳ್ಳಿ ಬರುತ್ತೆ, ಮಂಡೇ.
Writing a memo for Malad, this is 7. There was a Malad petition number 2, Council Malu K, and there was a name has been restricted as R2 Malad. So I'm just filing that along with the rest.
Serial number 10, my lords. In this matter, we had engaged a senior counsel, my lords. He is under the weather today. My lords may kindly have it next week.
The matter next week. Inform the other side.
Please, my lords. My lords, a date may be fixed subject to my lords' convenience. Apply.
Serial number 51.
Serial number 30 to 34, page number 5, 35 to 38, page number 6, 39 to 43, page number 7, 44 and 45.
Yeah, the point number 1 and 2 in this matters. I will have it done next week, any day.
You appear for
1 and 2, the point number 1 and 2. Yes.
So Mr. Ariga was required. Ariga was required to state what has happened. So let us see. I'll accommodate. Let him say why, what happened, and then I'll accommodate.
Number 8, 45, page number 9, number 46, 48, 7 Malad. Each Malad.
You inform the other side.
Other side also.
Serial. I request list the matter next week.
Serial number.
Yes.
Serial number 56, my lord.
Just wait. We haven't yet.
Page number 10, 49 to 55, page number 11.
51, my lord.
Yes.
Serial number 51, my lord.
Yes.
Kindly have it on 11th, my lord. I have to file rejoinder. They have filed objections. State has filed objections. I have to file some more documents.
List the matter on 11th.
11th.
Number 11.
Serial number 56, my lord.
Yes.
My lord, I appear for petitioner. My lord, I inform the other side, my lord. My lord, wherein, my lord, this batch of matters are ordered to be listed before their lordship, Justice Suraj Govindraj, my lord, on 12th, 9 September 12th, my lord. There are batch of matters.
What is the submission you are making? Please say what you want. An adjournment or what?
Adjournment, my lord. Sorry,
Right. List the matter week after next.
my lord.
Have you
Entry
informed the
murder,
other week after?
please, my lord. Entry murder may be extended, my lord.
The matter earlier granted is extended to the next week.
Sorry, oblige, my lord.
5 and 66. Number 13, 67. This one, next matter, serial number 1.
Also,
Number 2.
My lord, the writ of mandamus considers the representation made by the petitioner on dated 2021 period to change the revenue record to the name of petitioner, my lord. As per the final decree passed by the Honorable Senior Civil Judge Bangalore District.
EGA accepts notice for the
You
respondent.
have to accept my.
List the matter in preliminary hearing list on 5th. Just 1 minute, previous matter. Now, just in some of the matters, they are seeking on the basis of judgment and decree. So there, they are saying Lebanese sketch may not be required. In one matter, in any one matter, we'll examine it in detail. ಬಂದಿದೆ. You take out notice. This is 11E sketch. EGA accepts notice for the respondents. This is the matter week after next. We have ordered for notice, let us see.
Number 3.
It's an appealable order.
My lord, but then subsequently, my lord,
So the order of conversion can be challenged before the KAT. That's it. Specific to under, there is some one or two matters that you can challenge it before the KAT. Specifically, we have dealt with matters wherein appeal was filed against that order of conversion. Find out, we'll have it tomorrow. Monday, I'll keep open all your contentions, go to that.
I'll find out and verify.
There's some specific provision for challenge of orders of conversion. Relist the matter in the same stage on Monday, counsel for the petitioner to submit regarding availability of alternative remedy to challenge the order of conversion. Just find out. You take out notice, take out. AG is directed to accept notice for respondents 1 to 4. Emergent notice to respondents 5 to 10. But how are you going to serve on them? Which is the fastest mode?
They have undertaken by
Correct. So now how do you get them to the court at the earliest? You must tell. We can also issue notice to Tahsildar. Notice to be issued to respondents 5 to 10 to the jurisdictional Tahsildar, which would be in addition to emergent notice to the said respondent. You move the matter as soon as they are served. Now you have to actually challenge that sale deed, the second sale deed, before the civil court. That is the only permanent. I'll order for issue of notice. But what I'm saying,
My lord is correct. It is disobservation.
disposal. No, it's fair against.
It is a court order.
Yes. The petitioner has challenged the order of Respondent number 2, Deputy Commissioner. In Division Petition 126 of 2021, whereby the Deputy Commissioner has affirmed the order of dismissal of the appeal by the Assistant Commissioner. The case made out by the petitioner is that Nanjanna, father of the petitioner, had purchased the property bearing survey number 36, measuring 2 acres 25 guntas and 168 into 104 yards from Gangamma to sale deed dated 17/7/1942 with respect to an extent of 3 acres 24 guntas. It is further submitted that Srimati Gangamma had sold the entirety of her interest and property, and accordingly, there is no other land vested with Gangamma, the vendor of Nanjanna. It is submitted that revenue entries were subsequently transferred in the name of Nanjanna to an extent of the property conveyed through the sale deed. Full stop. Next. It is submitted that Gangamma, the vendor of Nanjanna, the previous sentence, that the revenue entries were affected to the previous sentence. To an extent of 1 acre 29 guntas only, though sale deed was conveyed with respect to an extent of 3 acres 24 guntas. Isn't it? Next. It is submitted that after the death of the vendor of Nanjanna, the remaining extent was remaining extent of land, the extent of as mentioned in the revenue entry of 1 acre 29 guntas was transferred to H.V. Shivaratnamma with respect to an extent of 1 acre 14 guntas. Within bracket 1 acre in survey number 36/18 and 14 guntas in survey number 36/4. It is submitted that such revenue entries are without authority of law, as after execution of sale deed with respect to an extent of 3 acre 24 guntas, Gangamma did not have any property left which could have devolved through persons claiming under her. Next. It is further submitted that Srimati H.V. Shivaratnamma had sold the property to Siddhalingayya to sale deed dated 27/1/2020. And mutation came to be effected in the name of Srimati H.V. Shivaratnamma. The validity of such mutation entry came to be challenged by the petitioner herein, son of late Nanjanna, before the Assistant Commissioner, and the appeal file came to be dismissed and the revision petition subsequently also came to be dismissed, affirming the order of the Assistant Commissioner. Next, it must be noticed that the entry in the name of Shivaratnamma was only pursuant to the sale deed executed in her favor on 27/1/2020. Uh, if revenue entry has been effected pursuant to the sale deed, the authorities were correct in affirming the revenue entry and refusing to interfere with such revenue entry. The only course of action available to the petitioner is to challenge the validity of the sale deed dated 27/1/2020, if so advised as per law.
And third column is
Huh?
second and third column is not. Gangamma export. Then Yoratnamma export too.
That also, one paragraph. The petitioner is also to challenge, if so advised, the sale deed executed by Gangamma in favor of Shivaratnamma on 26/3/2020. Both authorities have held similarly. Accordingly, petition is rejected at the stage of preliminary hearing itself. AG accepts notice for response 1 to 5. Yes. Huh?
But
I've mentioned it. And why because ಅವೆಲ್ಲ ನಿಲ್ಸ್ಬಿಡ್ಬೇಕು. That's your right order. One page synopsis, you just give the details. One page. If there's any correction to be added, in that you mention the dates of the sale deeds, and then what are the findings given by the Assistant Commissioner and the Revisional Authority. Just one page. So anything to be added, I'll add. Yes, yes. ಇಲ್ಲಿ ಇವತ್ತು ಫ್ರೆಶ್ ಆಗಿದೆಯಲ್ಲ ಕೊಟ್ಬಿಡಿ. Yes. Next time.
Writ of mandamus to consider far number 57 filed by the petitioner.
You. Petitioner has sought for direction for constitution of a committee for considering the application of the petition in Form 57 under the provisions of Section 94 Capital A of the Karnataka Land Revenue Act, read with Rule 108(c) of Karnataka Land Revenue Rules. Petitioner also sought for direction, issuance of direction to the committee for regularization of unauthorized occupation to consider application made by the petitioner. Next, the petitioner's limited prayer is for constitution of committee and for a direction for disposal of the application filed in Form 57. Next. It is submitted that the petitioner has been cultivating the land in survey number 57, measuring an extent of 3 acres, situated at Sagaramahalli village, Guntur Hubli, Taluk, Guntur district, for several decades. And in light of the scheme available, petitioner has sought for regularization of unauthorized occupation by filing application in Form 57 on 11/1/2019. Petitioner has produced the acknowledgement evidencing filing of Form 57 at Annexure D. He submitted that despite having filed the form, no steps are taken for consideration of the petitioner's application. The observations made in the BP 18682 of 2023 are taken note of. The court has taken note of the observations made in WP 13781 of 2023. Repeat para 3. And para 4. CGA accept notice for response 1.
Matter is not for consideration of step E.
Same order shall be disposed. Put it up. The petitioner. I sought for issuance of writ of mandamus direct respondent number 4 to consider the application filed under section 94A of the Karnataka Land Revenue Act, filed in form number 50 and 53.
We have produced the next minute, it says Form 50, but if the act were to be seen minute, it is Form 57. But the actual form itself will not have.
Where do you get that? Filed in form 57. Filed in form 57. Petitioner submits that petitioner's father has been cultivating the land in survey number 2 of Palinganahalli village, Barandur Post, Bhadravati Taluk, Shimoga district since 1969 with respect to an extent of 2 acres. Of 2 acres. Huh? Of 2 acres.
4 acres.
4 acres. It is submitted that in light of the scheme available for regularization of unauthorized occupation and cultivation, the petitioner has filed Form 57, copy of which is produced at Annexure B. But the said application file has not been considered till date. What is this Annexure D?
But that is, my lords, an order passed by the Assistant Commissioner, my lords, wherein he has remanded back the matter by Tahsildar to take action in accordance with law. Earlier, my lords, they had rejected it, saying that that is Gomala land. That, my lords, was rejected, and the Tahsildar, my lords, is directed to reconsider it in accordance with law. In spite of that, my lords, there is no action.
Submitted that on an earlier occasion. The petitioner had approached the Assistant Commissioner in case RA 90 of 2016-17 wherein there is a direction after setting aside the previous proceedings to place the application of the petitioner before the committee, copy of which is produced at Annexure D. And despite such order passed on 22/4/2017, it is submitted that the applications of the petitioner have not been considered. It is further submitted that further applications were made in Form 50 at Annexure E. Seeking for the same relief, as well as representation at Annexure F. In light of the limited prayer sought for, same is required to be considered in terms of applicable rules. Observations made in WP 18682 of 2023 are taken note of. Repeat para 3 and para 4. He accepts notice for the response. There's already one suit pending, isn't it?
18, and an interim order was operating against the defendant there. He suppresses that interim order and the proceeding and applies to the government for allocating that land for the purposes of a community hall. He gets an order in 14 and 18. 14 order is not disclosed, 14 order is referred in the 18 order. That 18 order is not produced in his written statement. We apply then in the RTI and obtain that order. And in that, on his application, the defendant's application, government has earmarked this land for the purposes of a subsidy hall. By Annexure A at page 21.
We'll take out notice. Let us.
We have an interim order against the defendant in that suit not to disturb possession. That order is suppressed, and in Annexure A is impugned.
Just take us to that order.
Yes, the order of the lower court. (175). At 177.
This is a suit filed by the
Filed by the
petitioner hearing.
Filed by the petitioner against the applicant, on whose application Annexure A has been passed. The applicant has suffered an interim order, which is in force even till today, which my lord will find at page 177.
Yes.
The interim application was not to interfere with the plaintiff's possession of those.
Now, you claim possession of that land, how?
We were allotted grant orders. Kindly see Annexure B at page number
No, just,
22.
Just before that,
Yeah.
just take me to the schedule. What is the schedule that you have described in the plain?
Plain. Or we'll see the plain
Site number 126.
at page number 124. There are 6 applicants, all of whom are petitioners before my lord. All the 6 plains have been produced. At page number 124 is the first petitioner's plain. The schedule is at page 120, 127 and 128.
127.
7 and 128. It's site number 126 and 127.
Now, all the sites put together
Yes.
are a part of the land granted at 8.
Yes.
That's your case. So what happened to the earlier grant?
We were the first grantees.
That has not been cancelled.
No, that has not been cancelled. And that is very conveniently ignored.
All this is in survey number
148.
148.
And my lord will see that the Annexure A endorsement is after the interim order in our favor. And even by Annexure A, my lord sees the terms and conditions, it is subject to any litigation or orders of the court.
That is the saving clause.
Saving clause.
Where do you get that? Now, last sentence. Last sentence.
Now, construction has been started now.
Okay, now verify. What they're only saying is if the earlier grants are not cancelled, earlier grants made in their favor. Correct. If it is not cancelled, and there's an order of injunction that is operating against him. Correct. So we may not stay the. You may not have committed contempt, but even if a grant has been made, he cannot put up construction in violation of the interim order. That's all. We will not enter into this till you get back on this. We will only say that in light of the interim orders, they cannot put up construction pursuant to Annexure A till the next. Insofar as the validity of the order at Annexure A, let it be tested. We will appeal to it tomorrow. This is the matter in the same stage tomorrow. AG accepts notice for respondents 1 to 5 and 7. No, 1 and 1, 2 and 7. And Council actually Devan Rappa is right to accept notice for respondents 3 to 5. Emergent notice. No, now only you take notice. We'll have it tomorrow. The AG accepts notice for respondent 1, 2 and 7. List for consideration of interim prayer in the same state in the preliminary hearing list tomorrow. AGA submits, you would obtain instruction. You just make a comparative table of your schedules in all the suits. Tomorrow we can. So what he's saying is that you can't he can't go against the interim order even if there is a grant made. The validity of the grant, of course, is to be tested. Yes.
Order that has been challenged. What happened, my lord, is the land in question.
Against
People.
this order, is there no
Well, the
alternative?
reason why I have filed the writ petition is this.
Hmm.
The reason for rejecting my prayer is citing the pendency of a writ petition, my lord, that has been filed by the state, which is stated to be pending before this honorable court. That is the reason, my lord, that is stated by the assistant commissioner. The status of that writ petition, my lord, I have produced at page number 88, annexure S, the internet copy, my lord, of the said writ petition. That writ petition, though, has been filed in the year 2016, it has not even, my lord, been posted on a single location, except barring posting before the Honorable Registrar Judicial for compliance. Now, state has filed this writ petition, and state now says that in view of that writ petition, my representation cannot be considered. And hence, my lord, I even going before the Deputy Commissioner will not change the status. What rather I would request is, my lord, may kindly consider clubbing this with that writ petition. If in that writ petition, my lord, there could be no harmful order.
Yes.
Page number 87, my lord, that is the reason that is cited. The pendency of the.
He accepts notice correspond 1 to 3. This the matter along with WP 53682 of 2016.
Other potential 79A.
But since 2013, why
My
did
lords, I was not aware about this order. My lords, so kindly look into the order, page number 27, my lord. Page number 17. It starts at 16, the next area. No, that is their case. That is the impugn order. What is?
strategy? Page number some different. Annexure A, which impugn order? Yes. Very vacant land. Petition. Yes. Thought for setting aside of the order. Number so and so. At the next year, dated 30th November 2013. By virtue of which the Assistant Commissioner has recorded a finding that the CB dated 19/9/2009 executed in favor of the petitioner hearing was in violation of provision under 79A and B of the Karnataka Land Reforms Act, and accordingly declared the sale deed to be illegal and directed for vesting of the land in the government. The council to the petitioner would submit that though the order is dated 30th of November 2013, there was no notice to the petitioner, and the said factum is found in the impugned order itself, and accordingly it is submitted that the order be set aside as being in violation of principles of natural justice and matter be remanded for fresh consideration. Peruse the order at Annexure A, when it is clear from the observations made in the said order that though notice was served through registered post to the address mentioned in the sale deed, same have not been served, and eventually notice has been served in the land itself. To the is served by taking note of the address mentioned on the land. Counsel for the petitioner asserts that the land is vacant land and nobody resides there. And accordingly, question of serving notice on the land did not arise. Said the contention requires to be accepted, and it would meet the interests of justice to afford an opportunity for the petitioner to put forth his case on merits in light of the substantive rights involved. It's also noticed that the findings that are made regarding violation of 79A and 79B are only on the basis of the report submitted by the Tahsildar, and in the absence of any opportunity for rebuttal of such information by the petitioner hearing. Taking note of the omission of 79A and 79B would be a fit case to set aside the impugned order and remand the matter back for fresh consideration. Accordingly, the order at the impugned order at Annexure A is set aside. Matter is remanded to the Assistant Commissioner for fresh disposal. Petitioner to be present before the Assistant Commissioner without further notice on 21st. Petitioner to put forth his case on merits before the Assistant Commissioner, and the Assistant Commissioner to take note of the legal consequence arising from omission of 79A and 79B. Accordingly, petition is disposed. Pass over. Not well. Yes.
Andaman is called for, but so motor proceedings were initiated by the Deputy Commissioner.
You find out the proceedings are concluded.
Yes, my lord, they have
Including,
concluded.
The writ appeal. 136 3 proceedings are closed.
Yes.
VGA accepts notice for respondent 1 and 2. This is the matter in preliminary hearing list. Date 7.
My lord, happy for the petition, my lord. My lord, Annexure K is the impugned order. Where is my?
As on date, whether revenue entries are in your name.
Yes, my lord, I am still in possession of the property because my lord, the order earlier order was set aside and the matter was remanded. He passed similar or same order without considering any of my content.
We produced latest RTC of
And the latest are
now, finally, the order of grant has been cancelled. That we'll consider on merits. And so we'll say status quo regarding possession and revenue entries as on date. In light of the contentions raised. And in light of the assertion that the petitioner is in possession of the land and revenue entries stand in his name
yes, ma'am.
as on date, there would be an order directing maintenance of status quo regarding entry and possession as on date. AG is directed to accept the notice correspondence 1 to 6. If you get that latest RTC, give it to the court officer along with the memo. From the website, you get an extract. Yes.
Annexure A, not the order of the deputy commissioner.
No, where was the earlier water course running?
Page number 39. Page number 39, last page.
Page?
Page 39, last page of.
39. This is the sketch.
Yes, the earlier case is on the left hand side. Now, not the case is on
Which is your survey number? Which is your
4 minutes.
Huh?
25/4. Second property, Lord.
Which is your
On the
neighbor?
bottom.
Which is your neighboring?
25/2. Other mailgade. Even notes have not at all applied. By showing my name, not the impute order has been passed. Annexure F ಮತ್ತೆ annexure G ನಲ್ಲಿ ನನ್ನ ಹೆಸರು ಇಲ್ಲ. Annexure F may kindly be seen, Lord. Page number 32.
There was no notice to you.
No notice. I have not at all applied. ಯಾರೋ ಚಂದ್ರಶೇಖರ್ ಅವರು ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ the revenue inspector and the Uttahsildar has recommended. That too, Lord, even in 10 days the order has been passed. 18ನೇ ತಾರೀಕು ರೆವಿನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ರೆಕಮೆಂಡ್ ಮಾಡ್ತಾರೆ, 29ನೇ ತಾರೀಕು ಡಿಸಿ ಅವರು ಆರ್ಡರ್ ಪಾಸ್.
Who has applied now?
ಚಂದ್ರಶೇಖರ್ ಅಂತ ಹೇಳ್ತಾರೆ. Lord, kindly go to page number 32, annexure F. ಅದರಲ್ಲಿ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ಬಿದ್ರಳ್ಳಿ ಹೋಬಳಿ ಜಿಗೆಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 25/2 ಮತ್ತು 25/4ರಲ್ಲಿ ಹಳ್ಳದ ತರವು ಖರಾಬು ಜಮೀನನ್ನು ಪಥ ಬದಲಾವಣೆ ಮಾಡಲು ಕೋರಿ ಚಂದ್ರಶೇಖರ್ ಅವರು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿ ವಿಚಾರದ ಬಗ್ಗೆ.
Is not the neighboring landowner.
ಅವ್ರು 25/2 ಅವರು ಓನರ್.
Now, in this proceeding, there was no notice to you.
No notice at all.
Report. Now, after the report, order is passed or not yet?
Yes, not annexure A is the order of the deputy commissioner.
Please read the relevant paragraph.
ಮೇಲ್ಕಂಡ page number 13 ಮೇಲೆ.
Yes.
ಮೇಲ್ಕಂಡ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವಂತೆ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ಬಿದ್ರಳ್ಳಿ ಹೋಬಳಿ ಜಿಗೆಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 25/2ರಲ್ಲಿ ಸರ್ವಿನ ಬಗ್ಗೆ ಮೂಲ ಖರಾಬು 1.08 ಗುಂಟ ಮತ್ತು ಹಳ್ಳದ ಬಗೆಗಿನ ಮೂಲ ಖರಾಬು 1.08 ಗುಂಟೆ ಖರಾಬನ್ನು ಪಥ ಬದಲಾವಣೆ ಮಾಡಿದ್ದಲ್ಲಿ 2.08 ಗುಂಟೆ ಕಡಿಮೆಯಾಗಿ ಸರ್ವಿನ ಬಗ್ಗೆ 0.8 ಗುಂಟೆ ಪಥ ಬದಲಾವಣೆ ಒಳಪಡುತ್ತದೆಂದು ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 25/4ರಲ್ಲಿ ಹಳ್ಳದ ಬಗೆಗಿನ 1.08 ಗುಂಟೆ ಮೂಲ ಖರಾಬನ್ನು ಪಥ ಬದಲಾವಣೆ ಮಾಡಿದ್ದಲ್ಲಿ ಒಟ್ಟು 3.08 ಗುಂಟೆ ಹೆಚ್ಚುವರಿಯಾಗಿ ಒಟ್ಟು 5 ಗುಂಟೆ ಪಥ ಬದಲಾವಣೆಯಾದಂತೆ ಅಳತೆ ಮಾಡಿ ನೀಡಿರುವ ದೃಢೀಕೃತ ಸರ್ವೆ ನಕ್ಷೆಯೊಂದಿಗೆ ತಹಸೀಲ್ದಾರ್ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ಬೆಂಗಳೂರಿನವರು ಪಥ ಬದಲಾವಣೆ ಮಾಡಲು ಶಿಫಾರಸು ಮಾಡಿ
ಸಲ್ಲಿಸಿರುವ ಪ್ರಸ್ತಾವನೆಯನ್ನಾಧರಿಸಿ ಕರ್ನಾಟಕ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮ 1969 ರ ಕಲಂ 28A ನಂತೆ ಪದಬದಲಾವಣೆ ಮಾಡಿ ಸದರಿ ಕರಾಬನ್ನು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ ಕಾಯ್ದೆ 1964 ರ ಕಲಂ 71 ರಡಿ ಸಾರ್ವಜನಿಕ ಉದ್ದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸಿ ಕೆಳಗಡೆ ಷರತ್ತುಗಳೊಂದಿಗೆ ಆದೇಶ. Even they have reduced my inland to an extent of 3.5 quintas.
3.5 quintas more in this land, and there is no notice.
No.
So let us see, but he should have been heard. The petitioner. Find out. So as of now, what is flowing?
ಇಲ್ಲ.
ನೀರಿಲ್ಲ.
ನೀರಿಲ್ಲ.
ಅಲ್ಲಿ ಇವಾಗ
ಇವಾಗೇನಿಲ್ಲ.
ಇವಾಗಿಲ್ಲ.
Even plus my land is converted long back. ಅದು ನನ್ನ ಜಮೀನಲ್ಲೇ ಪೂರ್ತಿ ತಗೊಂಡು ನಂದನ್ನೇ ಐನ್ಲ್ಯಾಂಡ್ 3.5 quintas ಕಡಿಮೆ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ಇವಾಗ ಅಲ್ಲಿ ಜಮೀನ್ ಇದೆಯಾ ಸೈಟ್ ಇದೆ?
ಜಮೀನೇ ಇದೆ, ಅದೇನು ಜಮೀನಾಗೆ ಇದೆ, ಕನ್ವರ್ಟ್ ಆಗಿದೆ ಅಷ್ಟೇ, ಜಮೀನಾಗೆ ಇದೆ, ಏನ್ ಲೆವೆಟ್ ಆಗಿಲ್ಲ, ಕನ್ವರ್ಟ್ ಆಗಿದೆ, ಫಾರ್ಮೇಶನ್ ಆಗಿಲ್ಲ.
Petitioner submits the change in the path of the
pathway of water channel.
Change in the pathway of the water channel that is affected in terms of the order at annexure A, resulting in proposed utilization of an additional extent of 3.08 quintas has been passed without notice to the petitioner. Subject to further consideration is the stay of the order at annexure A, while clarifying that there ought to be no obstruction to the pathway of the water channel previously existing as per sketch number 1 contained at page 39 of the petition. AGF accepts notice for respondent 1 to 3. This is the matter week of the next necessary statement of objections to be filed. But you must make that Chandrasekhar also is a party. Now he has made the application. So you make him the party. I give you permission now itself. You make him a party. Petitioner makes an oral request for impleading Sri Chandrasekhar and Srinivasaya.
Srinivasaya is myself.
Sri Chandrasekhar. So they sent notice to you after the order.
Never not. ಈಗ ಬಂದು ಅಲ್ಲಿ ಅಳತೆ ಮಾಡಕ್ ಬಂದ್ರೆ ಈಗಲೇ ಗೊತ್ತಾಗಿತ್ತು ನನಗೆ.
Column 5 ಅಲ್ಲಿ at page 14 they say ಅರ್ಜಿದಾರರಾದ ಚಂದ್ರಶೇಖರ್ ಹಾಗೂ last line column 5.
ನನಗೆ ಕಳಿಸೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ಯಾವ ನೋಟಿಸ್ ಕಳಿಸಿಲ್ಲ. I never received any notice.
He was the applicant and owner of the land in survey number
25/2.
25/2. In light of the controversy on hand, it would be appropriate to permit arraying of Chandrasekhar as an additional respondent. Accordingly, the oral request is acceded to. Necessary amendment to be carried out forth with emergent notice to the newly added respondent. Now itself you must.
I don't know it.
Put with it.
Long time in order to keep pending it, but not itself. It is direction to the not. Another collection of land, but it is the same model.
The committee resolution.
Not in the majority. Directly permitting all the community and then.
Where is the application?
July 2018. The application made by the petitioner again for the deadline. It's in July 2000.
Just find out, we'll have it next. No, but where's the acknowledgement for the, like form 53, form 70, formal is written, no?
The RTC did not. My name is figured in RTC. Let us be.
Let us see, you get it. AG is right to accept this. This is the matter, week after next. Let us see, let them get instruction. Because they have to get instruction. Yes.
Share is the owner of my lord, survey number 180/1, my lord. Annexure C is the revenue entries, my lord, standing in the name of the petitioner. Lordship, get it at page 19, my lord, 19. Sir, Lordship may kindly see, my lord, Janardana Naika, 0.90. My lord, the respond number 4 and 5 herein, my lord, claiming a right of way in the property of ownership property of the petitioner, my lord, makes an application to the Tahsildar. Not contending that I have obstructed the user of that road and may not sought for my not opening that road. Tahsildar gives an endorsement stating that my not this is a private property, whether there is a road or not has to be decided by a competent civil court, and thus my lord gives an endorsement. That endorsement came to be challenged by the respondent number 4 and 5 before the Assistant Commissioner, my lord. Assistant Commissioner 2 holds that my lord there is no document evidencing the roadway, my lord, is the ownership property of the petitioner. But holds it's a right of way, it's a easementary right, and nobody can have object the right of way, and thus directs that my lord Tahsildar to take action for removal of the obstruction caused to the road, my lord, if any. That is Annexure B order, my lord. As against that, I have filed an appeal before the Deputy Commissioner. Deputy Commissioner confirms that order, my lord, without application of mine. But my principal contention before the authority was that, my lord, Tahsildar has rightly passed an order holding that, my lord, a dispute is civil in nature. Over the private property, my lord, Tahsildar has no jurisdiction to decide and thus gives an endorsement, my lord. Kindly see the order of Assistant Commissioner, my lord, Lordship, get it an Annexure B at page, my lord, 15. The reasoning portion would be at the point number 7 at page 17, my lord. Page 17 ಅಲ್ಲಿ point number 7. ಆದರೆ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಶ್ನಿತ ಜಮೀನಿನಲ್ಲಿ ಮೇಲ್ಮೈದಾರ ಮನೆಗೆ ಹಾದು ಹೋಗುವ ರಸ್ತೆ ಇತ್ತು. ಅದನ್ನು ಮುಚ್ಚಿರುವರೆಂದು ತಿಳಿದು ಬಂದಿದ್ದರೂ ಸಹ ರಸ್ತೆಯನ್ನು ತೆರವುಗೊಳಿಸಲು ಆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು ಸರಿಯಲ್ಲ. ಈಸ್ಮೆಂಟ್ ಆಕ್ಟ್ ಪ್ರಕಾರ ನಡೆದಾಡಲಿರುವ ರಸ್ತೆಗೆ ಯಾವುದೇ ವ್ಯಕ್ತಿ ಹಾನಿಪಡಿಸುತ್ತಿಲ್ಲ. ನೋಡಿ, it determines the easement right of the parties and directs my lord to opening of the road, my lord, by the Tahsildar. Not my principal objection before the Assistant Commissioner itself, my lord, Lordship may kindly turn to Annexure E, my lord, page 28. Para 2. I have taken a specific contention that, my lord, the right of way claimed is in the private ownership property of the petitioner. The Tahsildar or the authority has, revenue authorities have no jurisdiction to decide such a right. It's a purely civil nature and therefore the Tahsildar has passed a proper order is my specific contention. My lord, now turn to Annexure J, my lord, the Tahsildar obtains a report, my lord, from the, at the time of inquiry at page 37. Typed copy at page 38, my lord. Page 38. May I read, my lord, one short para? 38 ali, sir. This is a report, my lord, secured from a surveyor, competent surveyor by the Tahsildar. It says, my lord, ವೃತ್ತ ಭೂಮಾಪಕರು ಮತ್ತು ನಾನು ಮುಂಚಿತವಾಗಿ ದೂರವಾಣಿ ಮುಖಾಂತರ ಸಂಬಂಧಿಸಿದವರಿಗೆ ಅಳತೆ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡಿ ಅಳತೆಗೆ ನಿಗದಿಯಾದ ದಿನಾಂಕದಂದು 20/2/19 ಸ್ಥಳಕ್ಕೆ ಹಾಜರಾಗಿ ಭೂಮಾಪಕರು ಅಂಡ್ ನಾನು ಸಂಬಂಧಿಸಿದ ಅರ್ಜಿದಾರರು ಮತ್ತು 180/1-2-3 ಖಾತೆದಾರರು ಸ್ಥಳದಲ್ಲಿ ಹಾಜರಿದ್ದು ಅವರಲ್ಲಿ ಇದ್ದ ದಾಖಲೆಗಳನ್ನು ಹಾಗೂ ಮಾಹಿತಿಯನ್ನು ಆಧರಿಸಿ ಅಳತೆ ಮಾಡಲಾಗಿದೆ. 180/1 ದಟ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್ ಲ್ಯಾಂಡ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮೈ ಲಾರ್ಡ್ 3 ಜನ ಆರ್ಟಿಸಿ ದಾರರು ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ಪಟ್ಟಾ ಸ್ಥಳವಾಗಿದ್ದು ಜಮೀನು ಸ್ಥಿತಿಯಂತೆ ಯಾವುದೇ ಖರಾಬು ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಸರಕಾರಿಯೂ ಇರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಈ ಹಿಂದೆ ಭೂಮಾಪಕರು ಅಳತೆ ಮಾಡಿ ತಯಾರಿಸಿದ ಸ್ಕೆಚ್ ಕಡತದಲ್ಲಿ ಲಭ್ಯ ಇರುತ್ತದೆ. ಆದರೆ ಯಾವುದೇ ದಾರಿ ಇರುವ ಬಗ್ಗೆ ಸ್ಪಷ್ಟವಾದ ಮಾಹಿತಿ ಇರುವುದಿಲ್ಲ. ಮುಂದಿನ ಕ್ರಮದ ಬಗ್ಗೆ ಕಡತವನ್ನು ತಮ್ಮ ಕಚೇರಿಗೆ ರವಾನಿಸಿ. This is the survey report, my lord, which also speaks there is no, my lord, right of way in the property in survey number 180/120.
What is the pathway that he is using?
But there is no pathway, my lord.
So how is it? How does he have a separate ingress and egress?
My lord, they are having a separate property, the way, my lord, they have been using. Now they want to make a, my lord, the roadway in my property, ownership property, by the other mode, my lord. Therefore, moves the Tashildar. Tashildar rightly passes an order to reject that application and direct the parties to competent civil court. My lord, for last 5 years, my lord, the proceedings are continued, my lord. And first time the Assistant Commissioner passes the order in the year 2021, my lord. That was stayed by the Deputy Commissioner during the pendency of the proceedings before him, my lord. Annexure H is the order of stay passed by the Deputy Commissioner, my lord. My lord. No. Annexure ಇಲ್ಲ ಆದೇಶ ನೋಡಿ ಸರ್, ಆದೇಶ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ 18ರಲ್ಲಿ ಪೇಜ್ 18 ಅಲ್ಲಿ ಆದೇಶ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಮೇಲ್ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಕಡಬ ತಾಲೂಕು ಕಡಬ ಗ್ರಾಮಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ತಹಶೀಲ್ದಾರ ಹಿಂಬರ ಸಂಖ್ಯೆ so and so ಹಿಂಬರವನ್ನು ರದ್ದುಪಡಿಸಿದೆ.
Don't take any action pursuant to the impugned order.
Yes.
When the counsel to the petitioner submits that the claim of the private respondent could not have been taken for pathway to the petitioner's private land, could not have been taken note of in the absence of any Karab land or in the absence of pathway being shown in the survey document. Reliance is placed on the report of the Tahsildar at annexure J.
The RTC entries also does not reflect any made of
Subject to further consideration, the respondent B is restrained from taking any action pursuant to the impugned orders. DG accepts notice to response 1 to 3, emergent notice to respondents 4 and 5. The submission of the
that is not my duty, my lord.
No, but,
My lord,
you only record your submission.
yes,
That there is
no roadway in my property, lordship.
no, but I'm saying there is some other ingress and egress.
They have been using, they say, my lord.
For the petitioner that there is other way of ingress and egress for the respondents. But now there is a private response. There is some scheme, I think, of the government latest. It says that these matters have to be settled. Just have a look at it recently.
This matter relates to the conversion of the use of a certain public land from a sarkari gundutopu to a burial ground. Now the petitioner is a developer and a land aggregator. Under a joint development understanding with a house building society, about 23 acres were acquired in about 15 survey numbers.
Why is it coming preliminary hearing?
Yes.
Why is it coming preliminary hearing?
Fresh matter.
Fresh
Yes,
matter.
because there was last time there was some amendment was there because subsequent to filing of the writ, in fact, another communication also was issued. So I in fact brought that also on record by way of an amendment.
We'll take out notice, let us hear the state and then we'll
Yes,
consider.
sir. But till such time, my lord, let them not change the nature of the land. That's all.
If somebody dies, that will come.
No, no. What is happening, my lord? By default, some 2-3 people have been buried in that Gundutopu. Now that should not become a precedent.
Let us see, let us see.
So they were trying to. My lord, the problem is that this 23 acres of residential layout is around this land. There were some negotiations from some local interested parties who wanted a part of this layout because it did not work out. It's just like how we see in the movies or novels, we see a lot that if you don't get what you want, then of course, then you make it into a dumping ground or a garbage unit or
Let us see, let us see. We'll have it next week, let him get back.
at the status quo can be made. It's the status
Let's see, if anybody dies.
quo.
Yes. AG accept notice for response 1 to 5. For consideration of interim prayers kept open. Relist the matter. When do you want? 12. Now we can't prevent them from using it as a graveyard.
No, as of now, it is not being used.
No, I'm saying you can't prevent the state from granting it for graveyard.
No, my lord, once it is allotted as for Sarkari Gundutopu, I'll.
They can deed is correct.
Yes, so there is a procedure, and my lord, they should have actually consulted with all the stakeholders.
You find out if it has been deed.
And the only stakeholder now would be the person who cannot speak. So,
No. Others who want to bury their dead also will. Let us see.
yes.
Yes.
For a mandamus, annexure mirror, page 15, third, regularization of unauthorized occupation was done and respect of 4 acre 10 guntas. Land has been granted in my favor. On 4/9/2014, the Sagoli cheat is issued. Page 17, at last, 4/9/2014. Thereafter, all I'm seeking is to enter my name in the RTC. I'm given the various representation. Annexure F, page 19 is the first representation. Seeking them to enter my name in the revenue record. Thereafter, my lord, Annexure G, page 20, another representation. Typed copy I have produced it, Annexure.
Dispose. The petition. The file represents the petition seeking issuance of writ of mandamus to direct the respondents 3 and 4. Respondent 4 only, isn't it? Respondent 3 and 4 to consider the representations dated 2/8/2019 made to the third respondent and representations at annexure F, G, G1 and G2 made to the fourth respondent. The petitioner submits that the land measuring 4 acres 10 hectares in survey number 257 of Kannur village, Anandpuram Hobli, Sagar Taluk, Shimoga district had been granted to the petitioner as per the proceedings of the committee
Ultimately, Sagoli cheat is issued.
and Sagoli and it is submitted that pursuant to resolution by the committee, premium was paid as is evidenced at Annexure C and Sagoli chit issued as per Annexure D on 4/9/2014. And despite representations, several representations for affecting revenue entries pursuant to the order of grant, the authorities have failed to act upon such representations. Considering the limited prayer sought for, the respondent number 4, only 4, isn't it?
Yeah, actually, Tahsildar my lord has granted. But Assistant Commissioner, they say that some of this year.
Respondent number 3 and 4 are directed to dispose of the representations made at Annexure F, G, G1 and G2.
All are addressed to respond number. F is addressed to respond number 3, my lord. Others are addressed to.
Accordingly, respondent number 3 is directed to dispose of the representation at Annexure
Yep, my lord.
F, and the respondent number 4 is directed to dispose of the representation at Annexure G, G1 and G2 within a period of 8 weeks from date of receipt of certified copy of this order. If the authorities are of the view that the representations are to be disposed of in the are to be considered in the affirmative, further action to be taken to consider the request of the petitioners expeditious.
Nineteen.
Indian matter, you know to say. Yes.
Matter, the institutional blood intended to purchase in extent of 3 guntas, only for the purpose of access to his agricultural land. And in order to obtain this LD, the petitioners have applied for Lebanese sketch for 3 guntas only. So at the time of preparation of the Lebanese sketch, they have prepared it for 3.34 guntas. But my vendor is not prepared to execute the sale deed for 3.34 guntas. He wants to restrict but only to 3 guntas. That is the practical difficulty which the petitioner is undergoing. We made a request for correction of the Lebanese sketch, but now they have refused to consider my request at annexure. Annexure P, page 119.
Just read that.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಾಮನಗರ ಜಿಲ್ಲೆ ಕನಕಪುರ ತಾಲೂಕು ಕೋಡಿಹಳ್ಳಿ ಹೋಬಳಿ ಹಣಕಡಬೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 87/2ರಲ್ಲಿ 3 ಗುಂಟೆ ಜಮೀನಿಗೆ ಬದಲಾಗಿ 3.5 ಗುಂಟೆಗೆ ನಕ್ಷೆ ನೀಡಿರುವುದಾಗಿ ದೂರಿದ್ದು 3 ಗುಂಟೆ ಜಮೀನಿಗೆ ಲೆಬನೀಸ್ ಸ್ಕೆಚ್ ನೀಡಲು ಹಾಗೂ 88/2 ಮತ್ತು 88/4ರಲ್ಲಿ ಲೆಬನೀಸ್ ಸ್ಕೆಚ್ ನಕ್ಷೆ ಅವಧಿಯನ್ನು ವಿಸ್ತರಿಸಲು ಉಲ್ಲೇಖ 2ರನ್ನೇ ಕೋರಿರುತ್ತೀರಿ. ಪರಿಶೀಲಿಸಿದಂತೆ ಹಣಕಡಬೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 70ರಲ್ಲಿ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಅನ್ವಯ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ 3 ಗುಂಟೆ ನಮೂದಿಸಿದ್ದು ಅಳತೆ ಸಮಯದಲ್ಲಿ 3.5 ಗುಂಟೆ ನಕ್ಷೆ ತಯಾರಿಸಿಕೊಡುವಂತೆ ಹೇಳಿಕೆ ನೀಡಿರುವುದರಿಂದ ನಕ್ಷೆ ತಯಾರಾಗಿ ಅನುಮೋದನೆ ಆಗಿದ್ದು ನಂತರದಲ್ಲಿ ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ಬದಲಾವಣೆ ಮಾಡಲು ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ. ನಂಬರ್ 88/2, 88/4 ಮತ್ತು 87/2ರಲ್ಲಿ ಲೆಬನೀಸ್ ಸ್ಕೆಚ್ ನಕ್ಷೆ ಅವಧಿ ವಿಸ್ತರಣೆ ಕೋರಿ ನಿಗದಿತ ಅವಧಿಯಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ನಾಡ ಕಚೇರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವಂತೆ ಉಲ್ಲೇಖ 1ರನ್ವಯ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ತಮಗೆ ಈಗಾಗಲೇ ಹಿಂಬಾಲ ನೀಡಿರುತ್ತಾರೆ. ಆದಾಗ್ಯೂ ಕೂಡ ನೀವು ನವೀಕರಣ ಸಂಬಂಧ ಯಾವುದೇ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುವುದು ತಂತ್ರಾಂಶದಲ್ಲಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ತಮ್ಮ ಅರ್ಜಿಯ ಕುರಿತು ಮುಂದಿನ ಕ್ರಮವು ಬಾಕಿ ಇಲ್ಲದ ಕಾರಣ ಉಲ್ಲೇಖಿತ 2ರ ನಿಮ್ಮ ಮನವಿಯನ್ನು ಈ ಕಚೇರಿಯಲ್ಲಿ ವಿಲೆ ಇಡಲಾಗಿದೆ.
They say that you have made some statement.
But I can't make that statement because there is a registered agreement of sale
I can't substitute the extent of land, my lord, orally.
Where is
My lord, they have made it. Please, but kindly see, my lord, the agreement to sell. At annexure D, page 62, my lord. 6/12/2021. This
Actually, they're required to make it in terms of
in
the,
terms of this agreement only. This is registered agreement. This was placed before them, saying that I am purchasing this plot under this agreement to sell. Annexure D, page 62, my lord. The relevant portion is at page 73. First, may kindly come to schedule, page 73.
we consider it.
It is
No.
not an impossible. I'm asking for reduction, not for increase.
Section 50. Just one. Rule 50. No, here there is no dispute.
There is no dispute.
That will be a disputed case if the rival claims. No, so now we'll record it. Now we're saying that he has not made such a statement and it cannot be contrary to that. No, correct. Now, under, why do you have to go and appeal? You only seek for rectification of the sketch. Under which rule this Lebanese sketch is prepared? 130. So now we're only asking for rectification in terms of the agreement. Now, consider that request and rectify it.
But there is earlier.
Yes.
But there is earlier direction of dishonorable court annexure J, page 96. Para 6 minutes, page 101. Having heard the learned counsel for the petitioner, learned
No,
government.
now you find out why again once more. Now we give another direction. Again, find out and come back.
Please.
No? There's no point because now we have an order passed already
Two directions not have.
at election J, isn't it?
Yes.
8 pages of direction. So let us see. Let's
And
not.
all the objections raised by the government for rectification of the 11 sketch has been considered. And this honorable court has said all those objections doesn't arise in this case because we are not using this plot for agriculture. It is only for pathway for to reach my agricultural land.
To find out what we only saying, here's a registered agreement. So now the sketch must be prepared so as to enable him to buy only 3 guntas. So if you make it for 3.5 guntas, he is not ready to sell.
If my vendor is prepared, I am prepared to pay additional amount. He is not prepared to execute the deed.
So you find out what is the technical difficulty. We'll list the matter in the same stage on 15th.
Okay. Specific ground by the business is not notice is not served. So there is an observation in the order that notice has been sent and served. That is not, it is not correct. Contrary to the order sheet kindly thing, necessary L. Not the page 165. There is no indication that notice has been issued. But it says that it is served on the land. 165 page annexure L. On 18/8/2009, Devanali Taluk Tahsildar Vanadi ಮೇರೆಗೆ ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸಲಾದ ನೋಟಿಸ್ ನೀಡಲು ಆದೇಶ. Next on 26/10/2009, so not present. Respondent to be served on the land also. Call on 14/12. Then on 14/12 ಪ್ರಕರಣವನ್ನು ಕರೆಯಲಾಯಿತು. ಪ್ರತಿವಾದಿಯು ಗೈರು ಭೂಮಿ ಮೇಲೆ ನೋಟಿಸ್ ಜಾರಿಯಾಗಿದೆ. ಪ್ರಕರಣ ವಿಚಾರಣೆ ತಗೊಂಡು.
You stay at a different address. You stay at a different address.
No, the very same address.
Yeah,
The sale deed.
Correct, but do you stay in the land or somewhere else?
Somewhere else.
Not in the land.
Not on the land. Then the second is, on account of the denial of opportunity, I could not report the report sent by Tahsildar. On that basis, now the order has been passed. To show the prima facie, one of the ground is that we are not agriculturalists. Annexure N, page 174. A certificate issued to show that we are agriculturists and we own agriculture land since 1970. Page 174.
Srinivas Reddy.
ಹೌದು, ಅವರು ನಮ್ಮ ತಂದೆ.
This is 79B.
ಹೌದು.
Just read the order.
Yes. ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರತಿವಾದಿಯರು ಕಾನೂನು ಉಲ್ಲಂಘನೆ ಮಾಡಿ ಜಮೀನು ಗಿರಾಯಿಸಿಪಡಿಸಿದ ಮೇರೆಗೆ ವ್ಯವಹಾರ ಕರ್ನಾಟಕ ಕಾಯ್ದೆ 79AB 80 ಅಡಿಯಲ್ಲಿ ವಿಚಾರಣೆಗೆ ಪ್ರಕರಣವನ್ನು ತಹಶೀಲ್ದಾರ್ ದೇವನಹಳ್ಳಿ ತಾಲೂಕಿನ ವರದಿ ನಂಬರ್ 7 ದಾಖಲಿಸಿದ ಪ್ರತಿವಾದಿ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ತಿದ್ದುಪಡಿ ಪ್ರಾರಂಭ ಆಗುವುದಕ್ಕೆ ಪೂರ್ವದಲ್ಲಿ ಇದ್ದ ವ್ಯವಸಾಯದ ವಿವರಗಳು ಹಾಗೂ ದಿನಾಂಕ 1/3/74 ಜಮೀನು ಪಡೆಯಲು ಪ್ರತಿವಾದಿಗಳು ಹಾಜರಾಗಿದ್ದಾರೆ ಅಥವಾ ಇಲ್ಲವೇ ಇವರ ವಾರ್ಷಿಕ ವರಮಾನ ಬಗ್ಗೆ ತಿಳಿಯಲು ಪ್ರತಿವಾದಿಗಳ ದಿನಾಂಕ 26/9 ಹಾಜರಾಗಿದ್ದಾರೆ ನೋಟಿಸ್ ನೀಡಲಾಯಿತು. ಪ್ರತಿವಾದಿಯವರಿಗೆ ಕರೆಪತ್ರದಲ್ಲಿ ಕಂಡ ವಿಳಾಸಕ್ಕೆ ನೋಟಿಸ್ ಅನ್ನು ನೋಂದಾಯಿತ ಅಂಚೆ ಮೂಲಕ ಕಳಿಸಲಾಗಿದೆ. ಸದರಿ ನೋಂದಾಯಿತ ಅಂಚೆಯನ್ನು ಸ್ವೀಕರಿಸುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ತಹಶೀಲ್ದಾರ್ ಮುಖೇನ ನೋಟಿಸ್ ಅನ್ನು ಕಳಿಸಲಾಗಿ ಜಮೀನು ಮೇಲೆ ನೋಟಿಸ್ ಅನ್ನು ಜಾರಿ ಮಾಜರ್ ತಿರುಗಿಸುತ್ತಾರೆ. ಪ್ರತಿವಾದಿ ಈ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರಾಗಿರುವುದಿಲ್ಲ. ಪ್ರಾಧಿಕಾರದ ನೋಟಿಸ್ ಅನ್ನು ಕುರಿತು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಲು ವಿಚಾರಣೆ ದಿನಾಂಕದಲ್ಲಿ ಹಾಜರಾಗದೆ ವ್ಯವಸಾಯಗಾರರೆಂಬುದನ್ನು ಸಮರ್ಥಿಸಲು ಯಾವುದೇ ಕಂದಾಯ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಪ್ರತಿವಾದಿ ಕುಟುಂಬದವರು 74 ಪೂರ್ವದಿಂದಲೇ ವ್ಯವಸಾಯ ಹೊಂದಿರುವುದು ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ 61 ಕಲಂ ಉಲ್ಲಂಘನೆಯಾಗಿ ಕಂಡುಬರುತ್ತದೆ. ಅಲ್ಲದೆ ಸದರಿ ಕ್ರಯಪತ್ರ ದಸ್ತಾವೇಜುಗಳಿಗೆ ಕ್ರಯವಾಗಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನಿನ ಆದಾಯ ಮೂಲದ ಆಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ notice I could have reported the report of the Tahsildar.
You can reconsider it. But why the delay?
This is what I explained in para 10. You are not aware of it.
But till 23, the Pani entry stood in your name.
Till Lord 2013, it was there in the name of the petitioner. Thereafter, Lord, it is mentioned as government.
Then you pay some costs. How much?
Reasonable cost.
The petitioner has sought for issuance of writ of section right to set aside the order dated 29/4/2011 made in so and so, whereby the assistant commissioner has recorded a finding that the sale deeds clearly the sale deed date that the sale deeds day number so and so dated so and so are in violation of provisions of 79A and B, and while holding the said sale deeds to be illegal, has directed vesting of the land with the government. The senior counsel appearing on behalf of the petitioners submits that though there is an observation made in the impugned order that notice was served to registered post. However, actually, there was no such service of notice. Then reliance is placed on the order sheet, and in particular to the entry made on 14/12/2009, wherein there is a mention that notice is served at the address of the land, which is the subject matter of the sale deed, which specifically stated that the lands are vacant lands, and question of serving notice at the said address did not arise. Next. Nevertheless, it is submitted that the order is passed on a presumption that the petitioner is not an agriculturist, and on a presumption that the sources of income from other than agriculture was about 25 lakhs, which are based on presumptions. It is submitted that the said two conditions made out under 79A regarding income and 79B regarding the petitioner belonging to a family of agriculturists as on the relevant date would be demonstrated if opportunities made out. In light of the mission of 79A and 79B, and taking note of the substantive rights involved, it would meet the ends of justice by setting aside the impugned order and affording an opportunity for the petitioner to put forth his case. It is noticed that the petitioner has produced a certificate at annexure N, which would indicate that the petitioner's father was a holder of agricultural lands as on the relevant date. It would, if an opportunity is granted, as is asserted by the petitioner may be in a position to substantiate the non-breach of the conditions under 79A and 79B, insofar as the delay is concerned. Said aspect can be taken care of by imposing costs. Accordingly, the order at annexure is set aside. Petitioner to present himself before the assistant commissioner without notice on 21st of September, petitioner to put forth his case upon merits before the Assistant Commissioner, and the Assistant Commissioner, when deciding the matter, is to take note of legal consequence emanating from the omission of 79A and 79B. The petitioner to pay cost of rupees 10,000 for the legal services authority. Accordingly, petition is disposed of. Yes, yes. What has happened? Instruction, huh? No, but we've said we are going to impose fast if instructions are not changed. I'll pass over. You telephonically get instruction. Call him up. Otherwise, tell him we are going to impose fast of 25,000 on the Tahsildar. Pass over after lunch. You call him and tell him. Yes.
Not directly respond to forum number 7. But earlier, the tribunal has observed that there was a matter pending before some report, and after disposal of the matter, some report, the matter will be taken up. So far, the matter has not been taken up. Even the file is not raised. But if the file is not raised, they have to take necessary steps to build up a new record.
Now, which matter has to be heard now?
But now, A is the forum number 7 by the father-in-law of the petitioner, on which there was an order by the line tribunal. Kindly see annexure B. Annexure B. Page number 17. ಈ ಭೂಮಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಜೈಟಿ ನಂಬರ್ 563 82 ನಂಬರ್ 76 ಈ ಪ್ರಕರಣ ಹೈಕೋರ್ಟ್ನಲ್ಲಿ ಕಡತವು ಹೈಕೋರ್ಟ್ಗೆ ರವಾನೆ ಆಗಿರುವ ಕಚೇರಿ ಟಿಪ್ಪಣಿ ಸದರಿ ಕಡತವು ಲಗತ್ತಾಗದೆ ಈ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು ಮಾಡುವಂತೆ ಹಾಗಾಗಿ ಅನಿರ್ದಿಷ್ಟಾವಧಿಗೆ ಮುಂದೂಡಲಾಯಿತು. ಹೈಕೋರ್ಟ್ನ ಮೇಲ್ಕಾಣಿಸಿದ ಪ್ರಕರಣವು
Is there a petition pending or was pending?
As on today, was pending. On that date, the petition was pending, as per the record. But who filed the said application, nobody knows. But we made necessary, the petitioner made necessary inquiry.
ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ರೂಮ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ
ಇಲ್ಲ ಸಂಬಂಧಿಸಿದ್ದು ಯಾಕಂದ್ರೆ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಇದ್ರೆ we could not be able to search, but ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಇಲ್ಲ.
Let us see.
It is only the Tahsildar who has to inform.
Find out that instant. Now there is no point in issuing mandamus. Let them find out and then we'll issue some direction. Otherwise it will be a bald direction. And again,
twice was has been provided to the learner.
Let us see. The AG is directed to obtain necessary instructions by the next date. Relist the matter on 15 in the same state.
Writ of mandamus, strength of 11 is regarding this article. The petitioner filed an application on 7/9/2021. Today, they have not issued 11 is the purchase of scheduled property, actually A and B, in the year 1997. All revenue records stand in the name of the petitioner. Even though the petitioner is 18 years old, application consider direction issuance of 11 is
say expeditiously, depending on the seniority, because we don't know how many other matters are pending. We can't,
2 years old.
But we don't know how many are pending before yours. We can only say expeditiously and dispose.
The petitioner is a senior, 18 years old, but only 6 months.
Correct, but we can't give a time limit Let us see. If within 3 months, they don't do, then you can file and I'll give you liberty to file an application to revive this petition. I'll say expeditiously and dispose of. I can't give a time limit because we don't know what are the other applications that are pending.
The government may take the inspection malad in this matter. How many applications is pending for?
Let us see. The petitioner has sought for issuance of. So that we just find out. We have asked some comprehensive. Every month you update it on the website and whatever. So at least they come to know where they stand.
Price time limit may be given in this matter. Because
No jumping the queue. I'll say expeditiously and I'll grant you liberty to move by way of an IA. Petitioner sought for issuance of writ of mandamus to direct respondent 4 to 6 to issue revenue sketch relating to land in survey number 22/1 measuring an extent of 2.5 guintas and land in survey number 22/2 to an extent of 6.5 guintas of Attibele village, Sulibele Hogli, Hoskote Taluk. As requested by him by way of representation and G and H. Taking note of the limited request that is made, the request of the petitioner for grant of revenue sketch relating to the land referred to above is to be considered and necessary orders passed expeditiously. Shall we say 3 months? If you can't, you move an IA. Within a period of 3 months from date of receipt of certified copy of your order. If there are circumstances constraining the authority from issuing the revenue sketch within the time stipulated, the authority concerned are to seek for extension of time. Accordingly, petition is disposed of.
Pertaining to 7980 proceeding, with respect to survey number 12/4, measuring 20 gutas land, my lord. Annexure A, my lord, the impugn order. No notice being served, my lord, to the petitioner. And also, my lord, the impugn order that exceeding of 2 lakhs rupees of 1961 Karnataka Land Reforms Act, my lord. My lord, that 2 lakhs rupees has been substituted during 2015, my lord.
Just read the order.
ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರತಿವಾದಿಯವರು ಕಾನೂನು ಉಲ್ಲಂಘನೆ ಮಾಡಿ ಜಮೀನು ಕ್ರಯಕ್ಕೆ ಪಡೆದುಕೊಂಡು ಮೇರೆಗೆ ವ್ಯವಹಾರವು ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ಅಡಿ 1961 ಕಾಲಂ 79A B ಅನ್ನು ಮತ್ತು 80 ಅಡಿ ವಿಚಾರಣೆ ಪ್ರಕರಣವನ್ನು ತಹಸೀಲ್ದಾರ್ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ರವರ ವರದಿ ಸಂಖ್ಯೆ 79 ಮೇಲೆಗೆ ರಂತೆ ದಾಖಲಿಸಿಕೊಂಡು ಪ್ರತಿವಾದಿಗಳಿಗೆ ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ಅಡಿ ತಿದ್ದುಪಡಿ ಪ್ರಾರಂಭವಾಗುವುದಕ್ಕೆ ಪೂರ್ವದಲ್ಲಿ ಇತರ ವ್ಯವಸಾಯ ಜಮೀನುಗಳ ವಿವರಗಳನ್ನು 1/3/2024 ಈಚೆಗೆ ಪಡೆಯಲು ಪ್ರತಿವಾದಿಗೆ ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. ಇಲ್ಲವೇ ಇವರ ವಾರ್ಷಿಕ ವರಮಾನ ಬಗ್ಗೆ ತಿಳಿಯಲು ಪ್ರತಿವಾದಿಗಳಿಗೆ ಅಂತಿಮ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಲು ತಿಳಿಸಿ ನೋಟಿಸ್ ನೀಡಲಾಯಿತು. ಪ್ರತಿವಾದಿಯವರಿಗೆ ಕ್ರಯಪತ್ರದಲ್ಲಿ ಕಂಡ ವಿಳಾಸಕ್ಕೆ ದಿನಾಂಕ 19/7/2013 ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ನೋಟಿಸ್ ನೋಂದಾಯಿತ ಅಂಕೆಯ ಮೂಲಕ ಮತ್ತು ತಹಸೀಲ್ದಾರ್ ಮೂಲಕ ಕಳಿಸಲಾಗಿರುತ್ತದೆ. ನೋಂದಾಯಿತ ಅಂಕೆ ಸ್ವೀಕೃತವಾಗಿರುತ್ತದೆ. ಪ್ರತಿವಾದಿಗಳಿಗೆ ಅಂತಿಮವಾಗಿ 18/8/2010 ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರಾಗಲು ನೋಟಿಸ್ ನೀಡಲಾಗಿತ್ತು.
This will dispose it of. the petitioner has sought for issuance of writ in the nature of certiorari to set aside the order dated 31/8/2018 made in so and so, clear column, whereby the Assistant Commissioner has declared that the sale deed dated 13/3/2012 has been executed in violation of 79A and 79B, and while holding the sale deed to be illegal, has directed for vesting of the land in the government. Third counsel for the petitioner submits that despite there being an finding in the order at Annexure A regarding service of notice, no notice has been served. It is further submitted that the authority has recorded a finding that the petitioner does not belong to a family of agriculturists, and accordingly has violated provision of 79B, and that the income of the petitioner has not been demonstrated to be less than the limit described under 79A. He submitted that such findings are based on conjecture and without any material, as the petitioner did not participate in the proceedings. Peruse the order. In so far as service of notice, authority has recorded a finding that notice is served. However, it must be noticed that the finding recorded with respect to the income from other than agricultural sources for the purpose of 79A, and the finding that the petitioner does not belong to a family of agriculturists as required under 79B, have been made primarily on the basis of the report of the other revenue officer that is submitted. The taking note of the substantive rights involved, an opportunity may be granted in the interest of justice to the petitioner to put forth his case and produce positive evidence to demonstrate that there is no violation regarding the income limit prescribed under 79A, and that he belongs to a family of agriculturists or was an agriculturist himself as on the relevant date as required under 79B. Accordingly, taking note of the change in law and omission of 79A and 79B from the statute, it would meet the ends of justice by affording an opportunity to the petitioner and to direct the Assistant Commissioner to reconsider the matter afresh. Accordingly, the order at Annexure A is set aside. Petitioner to present himself without notice before the Assistant Commissioner on 21st September. Petitioner to put forth his case on merits, and while the Assistant Commissioner reconsiders the matter, Assistant Commissioner to take note of the legal consequence emanating from omission of 79A and 79B. Accordingly, petition is disposed of. Yes.
Consider the representation annexure D dated 6/2023 to effect Kata in the name of petitioner. Land bearing survey number 43, measuring 1 acre 1 kunta, was granted in the name of father of the petitioner by law. Thereafter, Kata has been effected in his name. On 10/11/2020, the father of the petitioners have been passed away. Thereafter, a representation has been made on 6/4/2023 to transfer the Kata in their name. Till today, it has not been considered.
Yes. This is me. The petitioner has filed with as a sought for issuance of a writ in the nature of mandamus to direct the respondents to consider representation dated 6/4/2023 at Annexure G, whereby petitioner has sought for affecting Kata in their name. The facts that are made out are that the petitioner are that the father of the petitioner had made an application to the Tahsildar for grant of land, which eventually came to be made and Sagoli chit issued in the name of the father of the petitioner. It is submitted that consequent to issuance of Sagoli chit in the name of the petitioner's father, MR 6 of 2004-5 came to be effected in the name of the father of the petitioner, which is reflected in the RTC. Next, it is submitted that subsequent to the death of the father of the petitioner on 10/11/2020, petitioners have made representation to the Tahsildar requesting him to effect change in the Kata consequent to the death of the petitioner's father, which remains still to be considered. In light of the limited prayer made, the representation at Annexure G to be disposed of within a period of 8 weeks from the date of receipt of certified copy of this order. If it is found that the representation is to be considered in the affirmative, the request of the petitioner to be considered expeditious. Accordingly, petition is disposed.
Madam, directing the respondent to consider my representation pursuant to the registered sale deed executed by the Civil Court, Jagalur, Mailad, and reached the court proceedings have reached finality by RSA, through RSA, Mailad. I filed an application for change of mutation in my name, Mailad, in Annex J, Mailad. Annex F, Mailad. 88, Mailad. So far, not changing, Mailad.
Yes. This is for Kata. Huh? No, first Kata. First mutation.
Yes, mutation.
It's on the basis of court documents, including that has attained finality in RSA.
RSA. I produced RSA.
So then within 3 months you should no, only for mutation. As per the court order. Mutate the name of the petition. That's all. In case of now consequent to now OD proceeding.
No, Mailad. Court proceeding. Case 61, Mailad, RSA, Mailad. Reach the penalty. The appeal is filed by the Veerabhadrappa, Mailad, appellant, Mailad. This is 11th May, page 80, Mailad.
Suit for What is the suit for?
Suit for specific performance, filed by the this petitioner, decreed, and against which the one Veerbhadrappa filed an appeal, RA and as well as the RAC, both are dismissed. I have produced all the judgments.
The whole of the survey number or portion?
Portion of 11 guntas.
We will record in case 4D proceedings are to be done prior to effecting mutation or Lebanese state 4D proceedings, then they will do it online. The mutation and 4D must be done simultaneously. Page. If you consider his request, whatever is required to be done from his side, he will cooperate. Do it expeditiously. The petitioner. Has sought for issuance of writ of mandamus to direct the second respondent, Tahsildar, to consider the representations at annexure F, F, G, H, and J, whereby petitioner has sought for deletion of the name of the defendant in the suit, Sri Veerbhadrappa, and to include his name, taking note of the orders of the court. It is submitted that civil suit was pending in OS 21 of 2008, filed by the petitioner against one Veerbhadrappa, G.M. Veerbhadrappa, filed seeking relief of specific performance of contract, and the said suit came to be decreed, directing Veerbhadrappa to execute registered sale deed. The said suit came to be upheld in RA 18 of 2012 and confirmed in regular second appeal 1863 of 2013. Petitioner submits that despite the representations made, there is no effecting of mutation, and no steps are taken to complete his request as regards 4D proceedings, as is required. He submitted that if a Lebanese sketch is required, authorities are required to take steps for completion of the said process, and that the petitioner is willing to cooperate with the respondents by producing necessary documents as may be required. Third, AGA submits that in the event the mutation is to be effected with respect to a portion of a larger survey number, 11E sketch may be required, and that OD proceedings may also required to be completed, and the petitioner may be required to adhere to the directions in the circular. There is some circular dated 15/10/22, and subject to compliances on behalf of the petitioner, the respondent would consider the representation in accordance with law and take necessary steps. Taking note of the said stand, the representations of the petitioner at annexure F, G, H, and J to be disposed of by the respondent Tahsildar within a period of 8 weeks. Representation within a period of 8 weeks. If it is found that the representation is to be considered in the affirmative, the request of the petitioner to be taken up and concluded expeditiously. The respondent authorities are required to stipulate the compliances to be made by the petitioner, and the petitioner undertakes that all such compliances from their side will be made. Accordingly, petition is disposed of.
Minor application to conduct OD and others. They have not considered a thought for a direction, my lord. Tatkal Podi, your lordship, Tatkal Podi, in fact, they allowed to conclude it within 30 days. I filed the application in the month of October 2022. They have not done. So I am before your lordship. But there is a stay. There is a stay.
Subject to that, you do it. Subject to if it is stayed, you can still go ahead if the notification is stayed.
Yes, my lord. My lord, may I make one comment? Notification, acquisition proceeding is stayed. Thereafter, what happened, your lordship? The revenue entries have been changed in the name of because the issue is the beneficiary of the acquisition proceeding. Then I filed a contempt petition. Thereafter, again, the mutation entries have been changed in my name. So then now what happened, your lordship? The entire the survey number insofar as 29 is concerned, they collated the proceeding, the extent. That's my concern, my lord.
Subject to that, take note of the order in contempt, and you do it subject to that. Next week, let us see. Relist the matter of request made on behalf of AGA on 15.
I paid the process 3 times. Thereafter, I filed IF 1 of 2022. The same I is not present. Thereafter, I filed fresh application for paper publication. The same is not yet put up.
Notice complete. Third time you have not yet notice. Student is fast. Office note says only 2 times. Hmm. Hmm. You repeat that. Counsel for the petitioner submits a notice has been issued on the third occasion as well. Office to put up report regarding notice issued to the unserved respondent on the third occasion. Office to also put up a IA1 of 22 on the next date. Relist the matter week after next date. 15. Petitioner is permitted to take steps in respect of R5B once again. Huh? The interim order earlier granted is extended. Yes.
And the respondent number 11 already taken steps.
You have taken steps.
Taken steps.
Okay. What is the vacating stay file? One acre? Okay. 19? Well, 9, 19? Respondent number?
This is survey number 230/1. Is measuring 1 acre 22 guntas. This is originally belongs to J. Jangappa. J. Jangappa is the grandfather of the petitioners. The J. Jangappa died in the year 2006. Then thereafter, after death of J. Jangappa, the name of the one J. Krishna is entered in the revenue records. In the year 2006, as per MR number 52/2006-7, on 30/12/2006, the mutation entry in the name of J. Krishna. From in the year 1953 to even Azan today, there is no revenue entry stands in the name of Raswan number 6 to 10, nor their three diseases at any point of time. They have challenged the mutation entry in the year 2013-14, pertains to year 2006-7, 52 of 2006-7. In the year 2013-14, there is no condemnation of delay. Then, the Assistant Commissioner directly considered the appeal. RA number 367/2013-14. Annexure E, F, kindly see the annexure F. I have produced the order sheet of the order sheet of the Assistant Commissioner maintained by the Assistant Commissioner. Earlier instance, the petitioners have filed. The petitioners are the Saraswatama, who are the respondent number 6 to 10. Then, the Krishnappa, who is the dead person. They have filed against the dead person. They are the relatives of the J. Krishnappa. The petitioners are the relatives of the J. Krishnappa. They have filed appeal before the Assistant Commissioner against the dead person as for annexure F, in page number 53, in page number 53, Kindly see the respondent number 3, that is a Krishnappa, who is dead person. The petitioners are the relatives of J. Krishnappa. They are aware that he is died long back itself. They are even assuming that they are well aware that Krishnappa is dead. Even they have filed appeal against the J. Krishnappa only. Then they obtained the stay order against the mutation number 52/2006-7. Then they have filed appeal. Then again, on 10/2/2014. Kindly see the order sheet. The ವಾದಿ ವಕೀಲರು ಹಾಜರಿದ್ದಾರೆ. ಐಒ ಮುಂದುವರಿಸಿದೆ. Steps ಮುಂದೂಡಿದೆ. Then 17/3/2014. Then again IO extended. Steps taken on 19/6/2014. 18/9/2014. Kindly see ವಾದಿ ವಕೀಲರು ಹಾಜರಿದ್ದಾರೆ. R3 LRC ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. 151 ರೆಡ್ವಿ ಸೆಕ್ಷನ್ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಅರ್ಜಿ ಹಾಕಿದ್ದಾರೆ. R3 LRC 1 ರಿಂದ 4 ಪ್ರೋಸೆಸ್ ನೀಡಿ 20/10/14 ಮುಂದೂಡಿದೆ. Next, on 20/10/2014.
Yes, sir. Now we can, a simple solution to the problem is let the revenue entries continue as on date. However, we will clarify that the civil court which is deciding your matter can independently decide on the basis of claims of title, evidence what you are going to produce. If you succeed, the entry made will be subject to that. We will make it clear that the civil, despite the entry as on date, civil court can independently consider the rights of the parties in the suit.
No, my lord,
Now,
here, my lord,
now mutation stands in whose name now?
the respond number 6 to 10, my lord. My lord, 1 minute.
No, as on date mutation. No, correct. In the RTC, what is reflected in the RTC? No, you already filed your suit. What difference it will make in whose name entry stand as on date? Now, how does it make a difference to your suit? What happened to the DC's order?
My lord, kindly say, my lord, 1 minute, my lord. My lord, this is the order passed on. My lord, this is urgent to 2/2015, my lord, the assistant commissioner. The assistant commissioner, without serving the notice to the LRs of J. Krishnappa, they advanced the case from 2/2015. Then they have passed the order on 17/11/2014 itself, my lord. Therefore, this honorable court.
The order of the assistant commissioner will have to go as being passed against a dead person and in violation of principles of natural justice, isn't it? So that's why I'm saying it has to go. It's against it. Krishnappa is dead there. So the order passed by the assistant commissioner is admittedly against the. Then we'll send it back. That's all. We'll set it aside and send it back. That's why. Correct. No, that you can't. We'll send it back. We'll set aside the AC's order, send it back for fresh consent.
For a moment, kindly 14/12/2021, passed by this honorable court, 14/12/2021.
Okay, so we'll take note of it.
No, the assistant commissioner present before this honorable court.
That's
He
why
has admitted that there is a mistake order passed by the assistant
so we'll
commissioner.
set it aside.
He has filed the affidavit before this honorable court, about the mistake made by the assistant commissioner.
So we'll set aside the assistant commissioner's order. We'll set aside the assistant commissioner's order and remit it for fresh consent.
Both the orders, deputy commissioner and assistant commissioner. And restore the revenue entries in the name of earlier J. Krishna only. Since they are already trying to create third-party rates over the property. The 1953 onwards, I produced the
No, we'll set aside the DC order and the AC order and send it back for fresh consideration. And then both parties will undertake not to create third-party interest till the suit is decided.
How about?
No. Suit is filed by you. If the order of the assistant commissioner goes, matter goes as on the date of the order of the assistant commissioner, in whose name the revenue records.
As on the date of revenue entry stands in the name of J. Krishnappa.
So that will remain as it is.
Yes, correct, madam.
Anyhow, Krishnappa is dead. So he can't come and execute any. So let it be in the name of
Jai
Krishnappa.
Krishnappa.
Let the AC decide afresh. And then whatever happens, happens. Petitioner has sought for taking aside of the order. So the DC also is there. The order is no.
DC order is also, DC can simply confirm the orders of the assistant commissioner.
Has affirmed the order of the
Upon the orders of the
has the petitioner has received the order of 27/11/2014 passed in RA number so and so by the Assistant Commissioner, Bangalore South College, as per order at HAB, and petitioner has also challenged the affirmation of the order of the Assistant Commissioner by the Deputy Commissioner in revision petition 332 of 2014-15. The limited facts for the purpose of disposal of the writ petition is that the respondent number 6 to 11 had filed an appeal in RA 367/2013-14 challenging MR number 52 of 2006-2007. When the matter was pending before the Assistant Commissioner, it is noticed that the third respondent before the Assistant Commissioner, Sri Krishnappa, had died, and taking note of the same, matter was adjourned for taking of necessary steps as regards the legal representatives, and matter was adjourned to 2015. In the interregnum, matter was called on 17/11/2014, and observing that the legal representative, that notice was served on the legal representatives of respondent number 3, matter was posted for orders, and orders passed on 27/11/2014. The said facts are not controverted by any of the parties. What emerges is that the Assistant Commissioner, having issued notice to the LRs of the third respondent and fixed the date as 2/2/2015, ought not to have advanced the case to 17/11/2014. Such action of the Assistant Commissioner does not inspire confidence and is a clear violation of a procedure of fairness to be observed while conducting proceedings by a quasi-judicial authority. Apart from case being advanced on 17/11/2014, posting the matter on 27/11/2014 for orders and pronouncing the same earlier to the date of 2/2/2015, which was the original date of hearing fixed. Admittedly, has seriously prejudiced the interests of the legal representatives of the third respondent. Who are the petitioners here? Only on that procedural violation, order of the Assistant Commissioner requires to be set aside, and its affirmation by the Deputy Commissioner without taking note of the said lapse also requires interference in the order of the Assistant Commissioner. Accordingly, the order of the Assistant Commissioner at Annexure
Annexure D, madam. Annexure D.
At Annexure D and that of the Deputy Commissioner at Annexure E are set aside. Matter is restored, is relegated to the Assistant Commissioner to hold a fresh inquiry after affording opportunities to all, including the petitioners herein. Till a disposal of the proceedings before the Assistant Commissioner, the revenue entries would would continue in the name of deceased Krishnappa. Such order is passed while also taking note that OS 148 of 2015 has been filed by respondent number 10. Accordingly, petition is disposed of. All contentions are kept open. Needless to state, if the suit is decided during the pendency of proceedings before the revenue authorities, the entries will follow the result of the suit.
Not to create any third party rights. They already tried to create third party rights on the basis of the orders passed by the Assistant Commissioner.
Just 1 minute. As on date, it stands in Krishnappa's name, isn't it?
But they are already trying to create the third party right during pendency of the repetition also.
Now I set aside the order, so it goes back into Krishnappa's name. There ends the matter. Now, how can he execute? Yes. So what happened to the affidavit? Huh? I want the affidavit on record. We have passed on 8/8 itself, we have passed an order. So when we say it must be filed, it must be filed. Affidavit as directed by orders dated 8/8/23 and 17/8/23 is not filed. Same to be filed by the next date, failing which costs of 25,000 would be imposed on the concerned official. Copy of this order to be communicated forthwith by government advocate to the concerned official. Relist the matter on. Well, can I look at this? Please. No representation when the matter is called out. It is noticed that office had raised objection on 2/12/2022, including as regards deficit of court fee of rupees 200 to be paid. Matter was called before the registrar on 6/12/2022. and it is noticed that as office objection was not complied with, week's time was granted. After noticing partial compliance, further office objection was raised on 11/1/2023. Matter was called on 31/1/2023 and time was granted for compliance. Thereafter, matter was called on 18/4/23 15/6/23, 26/6/23, 21/7/2023, and 21/8/2023. Despite several opportunities, office objections are not complied and there is no representation on behalf of the petitioner and the matter is called. Accordingly, noticing that petitioner is not diligent in prosecuting the proceedings, petition is dismissed for non-prosecution.
They canceling the grant made into the petitioner. The of grant bearing cannot be for 4 measuring 4
Cancellation of grant. Let them file their objections. File your objections.
Only on the ground that not the special and assumption has given the findings that I have not submitted any documents for the grant.
Let us see, all cancellation of grants, they have to file in writing and then we'll decide. Statement of objections.
It may be remanded to question because I have produced all the documents another he may kindly be seen. Only the contention the given by the special and they have not submitted the relevant document.
Let him file.
Another H may kindly be seen.
Let him file these objections. Statement of objections to be filed within 2 weeks. This is the matter in B group. Interim order earlier granted is extended till the next day. This is that Hemavati, isn't it? Huh?
Hemavati Reserve project. My land is required for the Hemavati Reserve project. Award has been passed, and after verifying all the documents are grant certificate has been issued.
But then it must be called along with that group matter. List along with the WP number so and so.
Please come on.
Master plan. No. We have stated in the order that no doubt that it may be a ground for not converting, stating that it is in the master plan as a road. But he said that you cannot indefinitely postpone. So if you really intend to implement the master plan, you take a stand that we are not abandoning that road, we are going to do it. So when do you want it? Affidavit as directed in the order of 1/8/2023 to be filed. Relist the matter on 12. Now there are two things. Under section 69, this road will not lapse. So what will happen then? Permanently it will be as road. As long as it is shown as road, you can't give conversion because of 95. But if that cannot be an indefinite, either you have to say that yes, we intend to do the road in 6 months. And we have not abandoned that proposal. Because eventually you're going to acquire the land, isn't it? If it is a converted land, it will have more value.
Salute, what is 7 and 8 they ordered. Last tell regarding LR, they will file necessary application to the office. Matter mood of direction Milord is order, including order is directing to effect the khata in their name without making the petitioner as a party proceedings. As the purchaser of 2005, my vendor 1992 he purchased. Direction page number 25 Adesha. Bengaluru Dakshin Taluku, Uttara Bengaluru Grams, survey number 93 survey number 75 ರಲ್ಲಿ 1 ಎಕರೆ 10 ಗುಂಟೆ ಜಮೀನು ಮೂಲದ ಇನಾಮ್ ಭೂಮಿಯಾಗಿದ್ದು ಕೋದಂಡ ರಾಮಸ್ವಾಮಿ ದೇವರ ಉತ್ಸವ ಪರಿಕರ ಇತ್ಯಾದಿ ಸೇವೆಯ ಬಗ್ಗೆ ಸಂಜಯನವರಿಗೆ ಇನಾಮ್ ನೀಡಿದಂತೆ ಸದರಿ ಜಮೀನು ಅವರ ವಹಿವಾಟು ಸಾಗುವಳಿ ಇದ್ದಿದ್ದು ನೈಜವಾಗಿದ್ದು ಕೆಎಟಿ ಅರ್ಜಿ ನಂಬರ್ 17/11/93 ಆದೇಶದಲ್ಲಿ ಮಾರಪ್ಪನವರ ಹಕ್ಕನ್ನು ರದ್ದುಪಡಿಸಿ ಮರುವಿಚಾರಣೆಗೆ ಆದೇಶಿಸುತ್ತೆ. ಭೂ ನ್ಯಾಯಮಂಡಳಿ ವಿಚಾರಣೆ ನಡೆಸಿ ಅಂತಿಮವಾಗಿ ನಂಜಯ್ಯರವರನ್ನು ಇನಾಮ್ ಕಾಯ್ದೆಗಳ ಅಧಿಭೋಗದಾರರೆಂದು ನಿರ್ಣಯಿಸಿ ಅವರ ವಾರಸುದಾರರ ಮೊಮ್ಮಗ ಮುನಿರಾಜುರವರನ್ನು ಅಧಿಭೋಗದಾರರೆಂದು ತೀರ್ಮಾನಿಸಿರುತ್ತಾರೆ. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣವನ್ನು ವಿವರವಾಗಿ ವಿಚಾರಣೆ ನಡೆಸಿ ಮಂಜೂರಾತಿ ನೈಜತೆ ದೃಢಪಟ್ಟಿರುವುದರಿಂದ ಮೂಲ ಮಂಜೂರುದಾರರ ಕಾನೂನುಬದ್ಧ ವಾರಸುದಾರರಾದ ಮುನಿರಾಜುರವರ ಎಲ್ಲಾ ವಾರಸುದಾರರ ಹೆಸರು ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಸೋನ್ಸೋ ಸರ್ವೆ ನಂಬರ್ ಮುಂಚಿನ ಜಮೀನಿಗೆ ಕಂದಾಯ ದಾಖಲೆಯಲ್ಲಿ ನಮೂದಿಸಲು ತಹಸೀಲ್ದಾರ್ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕಿನವರೆಗೆ ಆದೇಶಿಸಿ ಪ್ರಕರಣ ವಿಚಾರಣೆಯನ್ನು ಮುಕ್ತಗೊಳಿಸಲಾಗಿದೆ. But kindly see that my sale deed is annexed B page 26 next document. I am the purchaser of the 2 sites in the same extent of same survey number 24/3/2005. My vendor purchased from their vendor in 1997.
But it's all temple land.
Milord, this my vendor is one of the Inam Abolition Act has been confirmed. Same is forthcoming from the order of the.
Okay, but now the High Court's order, pursuant to the High Court's order only, this inquiry was.
No, Milord. What happened, Milord? Earlier, my vendor was only made as a party. I am not made as a party in any of the proceedings. In the behind back of the purchaser, Milord, though we have purchased the property in 2005, proceedings initiated in 2008.
This requires some hearing.
Only I am saying not to change the kata. What is maintained regarding revenue interest, Milord? Because we are the BBMP kata is there. We are running factory therein. We have produced all the material documents.
The change of kata was pursuant to the order of this court.
This court, not this court. Till this day, it is in the name of my vendor RTC 161. May kindly look at it.
ಉಲ್ಲೇಖದ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ.
ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಏನಂದ್ರೆ your lordship may kindly see matter was remanded to re-enquiry.
ಉಚ್ಚ ನ್ಯಾಯಾಲಯ.
Sorry, ಉಚ್ಚ ನ್ಯಾಯಾಲಯ. And Honorable High Court direction not granted remanded the matter to reconsideration of the grant. Where that also Milord no notice was served to the required parties. That is the direction. Make all necessary parties and enquiry will.
Where is that order?
Milord,
19710.
that is. Petition number page 149. May kindly look at Milord. Annexure J. The order dated 18th September 2013, K.M. Chandrakala. She is the respondent before the contesting respondent. She is only. Milord, wherein also we are not parties. Kindly see the order, Milord. Relevant paragraph in 152 onwards, Milord. Why the matter was remanded to special DC? The direction, Milord, in view of the fact there is a controversy as to filing of the application and observations made by special deputy committee.
153.
Page 152, last paragraph. It will para will start from 152. Last. In view of this reason, Milord, the second para clearly indicates counsel for third respondent submits that Anjaya, father of the Marappa, had filed an application in 1969. That has to be taken into consideration. It is submitted the application filed by Anjaya, father of the Marappa, was not rejected. Anjaya was advised to file an application in prescribed form and he has filed. However, same has been controversial by the other side. In view of the fact there is a controversy as to filing of the application and observations made by the Special Deputy Commissioner, the impugned order dated 16/5/2011 is set aside. Matter is remitted to Special Deputy Commissioner for Commissioner first to consider the application filed by the parties based on the documents and they sought to produce before the court in support of their filing application. Secondly, it is also to be considered whether both the petitioner and respondents have filed an application or not. And thirdly, whether the parties are entitled to re-grant according to law and therefore pass necessary orders according to law. Therefore, with these observations, petition is allowed. Parties are directed to appear before the pursuant to that, my lord, as on that also, the deputy commissioner from the before my vendor has got to notice page number 23 in the impugned order.
Complete Madu, what it said, further, any of those persons who claim to have purchased property by a subsequent transaction, if they have got any locus, their application would be considered by the Special
Deputy
Deputy
Commissioner, after hearing any objections for such application, it is left open to the parties to urge all the contention.
Now, after this order,
Yes, sir.
you did not go before.
I am not a party, my lord, for this order also. My vendor is this. I am the third purchaser of the property. My vendor has brought to the notice regarding to the officials before the Special Deputy Commissioner order. It is forthcoming, my lord, in page number 23 regarding sale of property. Though, my lord, they are not made as a page 23, may kindly look at, my lord. First paragraph, my lord. ಮಾರಪ್ಪನು ನಂಜಯ್ಯನ ಮಗ ಅಲ್ಲವೆಂಬ ಬಗ್ಗೆ ಸಹ ಪರಿಶೀಲಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಇನಾಮ್ ಅಬಾಲಿಷನ್ ಕಾಯ್ದೆ ಜಾರಿಗೆ ಬಂದ ಸಮಯದಲ್ಲಿ ಮಾರಪ್ಪ ಅಧಿಭೋಗದಾರರಿಗೆ ಹಕ್ಕು ಮಂಜೂರಿಗೆ ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು. ಅದರಂತೆ 30/9/78 ಆದೇಶದಲ್ಲಿ ಸ್ಪೆಷಲ್ ಡಿಸಿ ಇನಾಮ್ ಅಬಾಲಿಷನ್ ಅವರು ಅಧಿಭೋಗದಾರಿಕೆ ಹಕ್ಕನ್ನು ಮಾರಪ್ಪನ ಹೆಸರಿಗೆ ನೀಡಿ ಆದೇಶ ಹೊರಡಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಜಮೀನು ಮಾರಪ್ಪ ಸುಶೀಲಾ ರೆಡ್ಡಿಯವರಿಗೆ ಮಾರಿದ್ದು. ಸುಶೀಲಾ ರೆಡ್ಡಿರವರು ವಾಹಿದಾ ರೇಖಿರವರಿಗೆ ಮಾರಿದ್ದು. ವಾಹಿದಾ ರೇಖಿರವರು ಅವರ ಜಿಪಿ ಹೋಲ್ಡರ್ ಮೂಲಕ ನಿವೇಶನಗಳನ್ನಾಗಿ ಮಾಡಿ ವಿವಿಧ ವ್ಯಕ್ತಿಗಳಿಗೆ 1991-92 ಮಾರಿರುತ್ತಾರೆ. We are all purchasers from 91. I am the purchaser of 2005 sites. They disclosed with regard to sale of property by my vendor and previous vendor and their vendor. In spite of that, behind back this order was passed.
Now, finally,
Yes, my lord.
all your rights are subject to the conferment of occupancy.
Occupancy rates. My vendor's occupancy rates was confirmed by 1978 order. It was not cancelled by any authority till this day. That is my case.
Pursuant to the order at Annexure A,
Yes, my lord.
there is no change in the revenue.
No, currently I have produced the RTC claim this similar till I filing the petition also. It is in the name of my vendors Vaida Rekhi. I have produced the RTC. Annexure L, page 161. Page 161. Third, Wahida Rekhi. Order was passed in 2019. Present now, we are filed application. When the authorities come to spot inspection for making pata, then we objected. Then only we came to know and we have filed this.
Out of the contention that pursuant to the order at Annexure A, though passed on 24/9/2019, revenue entries have still not been changed. In taking note of entry at Annexure L and also the reference to subsequent transactions and creation of third-party rights at internal page 5 of the order at Annexure A, and that such of the persons were not issued notice in the proceedings before the Special Deputy Commissioner, there would be an order for maintenance of status quo with respect to revenue entries as on date. The petitioner undertakes not to create third-party rights.
2022. Even latest also, that is as per the knowledge of the petition.
File along with memo.
Yes, sir. Yes, sir. Yes.
By the end of today.
Yes, today only I will take print out and I will
supplement. Whatever the present as and today's article.
Steps to be taken as regards deceased R6.
R5 already filed.
And steps to be taken as regards deceased R6 and steps as regards R7 and RE. The request is made for consideration of interim prayer in light of the imminent change of revenue entries pursuant to the order at Annexure A. In light of the said request, consideration of interim prayer is considered. The held with is ordered. Yes.
Honorable Court has directed us to ascertain whether there is a division bench working in KAD or not. Portal number 1, division bench is there. This is the order passed, interim order passed by the portal number 2, my lordship.
But now they cannot consider. No quorum, is it? Functioning.
Yesterday I went, my lordship, yesterday I went and verified personally, my lordship. Portal 1 is division bench is working. But I don't know, my lordship, whether they are retiring or anything. This is 19 matter, 2019. This matter is 2019. Here, what happened, my lordship? An interim order was granted after lapse of about 8 years, my lordship. My about 11 years, my lordship. My podium done in the year 2002, my lordship. And I got converted the land for the industrial purpose. And
Let us see. We'll have it next week. You argue. Let us see. We'll direct the disposal of the appeal only.
that's what, my lordship. When there is no sitting, my lordship, when there is no forum, even this honorable court directed, my lordship.
We'll observe it. If there is any lack of forum, the registrar KAT to ensure that it is assigned to a bench having.
Yes. They should not influence on the orders passed by the present order, my lord. They should not think that it has been confirmed by this honorable court. That clarification is needed.
Petitioner. Sought for influence of request to set aside the order passed by the Karnataka Appellate Tribunal in revision petition number 53 of 2019, dated 27/4/2023, whereby the Karnataka Appellate Tribunal has by its order
Seven four 20. 5.
has restrained Octopus and 4D proceedings for a period of 6 months or till appeal is disposed of. Though various contentions have been raised, including on merits regarding the order passed by the Karnataka Appellate Tribunal, it would be appropriate if a direction is granted to the Karnataka Appellate Tribunal to dispose of the revision petition 53 of 2019 within a period of 3 months from date of receipt of certified copy of this order. If for any reason the concerned bench lacks quorum, the registrar of the Karnataka Appellate Tribunal to assign the matter to a bench having quorum in order to ensure that the matter is disposed of as directed by this court. Needless to state that the court has not adjudicated on the correctness of the order of the Karnataka Appellate Tribunal dated 27th April 2023 and accordingly the findings recorded are in the said order are to be construed as being made only for the purpose of granting interim relief, and the appellate tribunal will be at liberty to take an independent decision if a case is so made out while hearing the main appeal. All contentions are kept open, petitions accordingly disposed. Notice so R9 is viewed in light of the order disposing of the petition, wherein the only direction passed is for expeditious disposal, and accordingly, the interests of unserved respondent would not be prejudiced. Pass over. Yes. Step are not required.
I am not transferring the unity against 3 and 4.
Yes, survey work. Then you carry out with whatever, unless there is any legal impediment preventing you from carrying it out, you complete it.
Yes, coding.
Complete the proceeding. You dispose it of.
Site is concerned the same.
No, already you are in the process of considering it, isn't it? It's already you are halfway through it. So we'll direct it to be continued and completed. If he is required to make online in the interregnum, he will do it. But it must proceedings that have already taken place must continue. They want some circular they have passed, directing it has to be an online application. We will, you file it, but we'll say they will complete the process that is already initiated by them under the old application.
There is no notice or halfway, they stop the.
No, so we'll ask them to complete it. There is one circular of 15/10/22 which requires online application to be made. We'll record the undertaking that you will do it, but they will complete it in taking note of the earlier application. The petitioner notice to R3 and R4 is dispensed with as the only order that is sought for is dispensed with at the risk of the petitioner. Next, petitioner sought for issuance of direction in the form of mandamus directing respondent 1 and 2 to carry out the survey work by through 4D proceedings after notice to all concerned parties and by taking police help. It is submitted that proceedings have not progressed to a logical conclusion and that there was resistance at the ground level as could be made out from the communication at Annexure A, whereby the Assistant Director of Land Records has addressed a communication to the who is that? To the Annexure A. Is addressed to the Annexure A is a communication addressed to
the police, inspector of police land order.
the Inspector of Police, Jaipura Police Station, whereby the authorities have sought for police for the deployment of police during the process of survey. It is to be noticed that once the process of Adbust and Pudi is set into motion, authorities to take assistance of police as is noticed in the communication of 9/9/2022, and the police authorities are required to assist as required. Authorities should complete the proceedings expeditiously as long as there is no legal impediment to conclude the same. Learned AGA submits that though there have been certain objectors, there is no legal impediment for continuing with the 4D proceedings. Accordingly, petition is disposed of, directing the respondent number 1 and 2 to complete the proceedings while taking assistance as noticed in Annexure A as may be required. Accordingly, petition is disposed of.
Agricultural landlord of Africa not granted without any due process law. Kindly see on page 27.
We'll have it in the fresh matters list on Monday. What is the office objections?
I've applied, now, and director AB and H, I'm not relying on that, it is for reference purpose.
There's some other office objection raised.
I've complied with that.
You know, what's that?
Please, I will look into it. Monday, Lordship, I can have.
List the matter and fresh matters list on Monday.
Please.
Office objections to be complied with in the interregnum 230. The number? Yes.
I'm here, my lord. No.
14.
With your lordship kind permission.
Just 1 minute, just 1 minute. 40. Oh. You want it on some other day? No. Relist the matter next week. No? Okay. Wednesday. Relist the matter on Wednesday. 7th.
Your lordship permission.
I didn't hear nice.
ಸರ್ ಹೇಳಿ ಸರ್
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್ ಹೇಳಿ ಕೇಳಿಸ್ತಾ ಇದೆ
ದಯವಿಟ್ಟು ನೀವು ಮೈಕ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು ನಂಬರ್ಗಳೇ ಕೇಳಿಸಲ್ಲ
ಹೌದಾ ಸರ್ ಆಯ್ತು ಸರ್ ಕೇಳಿಸ್ತೀನಿ ಸರ್
ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 57 ನಲ್ಲಿ
57 ಸರ್
ಅವ್ರ ಕಾಪಿನೇ ಸರ್ವ್ ಮಾಡಿಲ್ಲ
ಹೌದು ಸರ್
48 ಅಲ್ಲಿ ಅವರು ಡೈರೆಕ್ಷನ್ ಇದೆ ಟು ಸರ್ವ್ ಕಾಪಿ ಅಂತ
ಸರಿ ಸರಿ ಇಲ್ಲಿ ಬಂದ್ರೆ ಹೇಳ್ತೀವಿ ಸರ್ ಅವ್ರಿಗೆ
ದಯವಿಟ್ಟು
ಓಕೆ ಸರ್ ಆಯ್ತು
ಸರ್ 61 ಸರ್
61 ಹಾ
61
ಇವಾಗ ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತಾರೆ 61 ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತಾರೆ ಬನ್ನಿ ಲೈನ್ ಅಲ್ಲಿ ಆನ್ಲೈನ್ ಅಲ್ಲಿ
ಸರಿ
ನೋಡಿ ಅದನ್ನ ಪುನಃ ಹಾಕ್ಕೊಡ್ತೀರಾ? ನನ್ನದೇ ಮುಖ ಬರ್ತದೆ. ತಪ್ಪೋಯ್ತು ಅದು. ಎಂತದ ಯು ಆರ್ ಯೂಸಿಂಗ್ ಎಂತದ ಬರ್ತದೆ ನೋಡಿ, ಹೀಗೆ ಬರ್ತದೆ. ಅದು ಸರಿ ಬರ್ತಿತ್ತು, ಅದು ಅದೇ ಬರ್ತಿತ್ತು ನೋಡಿ. Meeting ಆಯ್ತಾ?
But I'll get this argument by today. Today and tomorrow coming. After Monday, I will take a 45 minutes and go.
ಬೇರೆ ಯಾರಿರ್ತಾರೆ ಬೇರೆ ಯಾರಾದ್ರೂ ಮಾಡ್ಲಿ.
ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್ ಮಾಡ್ತಾರೆ. ಅವರು ಇದಾದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ.
ಅದಕ್ಕೆ ನೆನ್ನೆ ಒಳ್ಳೆಯವ್ರಿಗೆ ಹೇಳಿದೆ, ಗುಂಪಿನಲ್ಲಿ ಗೋವಿಂದ ಅಂತ ನಾನ್ ಮಾಡ್ತೀನಿ ನೀನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಯಾರು ಮಾಡಲ್ಲ ಅಂತ.
ಎಲ್ಲರೂ ಮಾಡಾಗಿದೆ.
ಮಂಡೇ
Monday, I will meet at 4 o'clock. I will come and ask them after 45 minutes. Sorry, my lord.
No, that's it. We will start matter on Monday. Same stage. So when do you want it? We list the matter on 13. 13ನೇ ತಾರೀಕು. 13ನೇ ತಾರೀಕು. They will come back. Yes. Monday. We list that. Or you want it on Wednesday? 7th. We list the matter on 7th. Yes. What about the office objections? No order is passed considering your interim prayer.
Without there being an order, showing
They may have done it. We have to find out from them. Let them know. Now, in making the grant, they may have followed the procedure. We'll find out. We'll ask them to get back with instruction and have it next week. They may, correct. That you are saying, they may have done it. We'll ask them to come back with instruction.
Me and my husband are recognized as the farmers and we have been awarded for the dairy farming and if the solid management can come.
Let's see, let us. Now you find out if you have followed the procedure for divesting the Kumki rights. I'll have it next week. You have to get instructions by them. PG is directed to accept notice for the respondents 1 to 4. Emergent notice to 5 and 6. Consideration of intent prayer is kept open. List the matter on 20th. Let us see.
Now they have
Earlier date.
already they are
Take the earlier date.
produced the photographs to show they have started leveling of the work.
Let us see. 14.
Till them at least let them maintain status quo.
Let us see. Let us
No, I
see.
can understand, my lord. Who it is for public purpose. Government run, that's why I have produced the article.
Correct. We don't know. They may have followed the
My lord,
procedure.
the order I have produced, my lord.
They may have followed the
No, my lord. Kindly see, my lord, the order itself.
Let us see. Let us see. Let us see.
Tahsildar, I'm sorry, my lord.
No, that's okay. I'm saying let us see. We'll find out.
Only 1 minute, my lord. I request my lord. Turn to page 47 for a minute. Page 47.
So now if the government wants,
Let them take, my lord. Total extent itself is more than, my lord, 100 acres there. Kindly see page 47. Tahsildar refers. Assistant Commissioner proceeds to pass order. Actually, under section 71, my lord, the authorized person itself is Deputy Commissioner. And they have to withdraw the Kumki privilege first, then they have to pass order. They have not considered my case for interim relief, my lord. I am before my lord.
let us see. Let them get back with some instructions.
May I seek, my lord? It is Monday, my lord. I have produced photographs to show that, my lord, now they have started the work of leveling. They proceed further, my lord, my request will become interesting.
Wednesday you get back. Deals the matter on Wednesday in the preliminary hearing list. Office objections to be complied with in the interregnum.
Office objection is with regard to the prayer relief sought for in the main petition. That is overruled.
Office objections kept in abeyance.
Right. In one for impeachment and one for amendment. The amendment sought for is addition of one ground and ground.
We'll allow the amendment.
Refix. It's only to refix the Harpasa. Fixing the Harpasa is mentioned as fix.
What is the impleading?
Impleading, my lord, I have sought to implead the ADLR Yelahanka Taluk.
You accept notice for that. The IA 2 of 23 has been filed seeking for amendment to introduce additional pleadings by way of additional grounds in light of the reasons asserted. Taking note of the government's made applications allowed amended petition to be filed. A 3 of 23 has been filed seeking to implead the implead whom?
My lord, so IA1 has been filed by me. IA3 has been filed by another private party, my lord.
Just one minute. IA 1 of 23.
Yes, my lord. IA1 of 23 is ADLR Yelahanka Taluk.
IA 1 of 23 has been filed seeking to implead the Assistant Director of Land Records, Yelahanka Taluk, taking note of the nature of controversy involved. It is found appropriate to allow the application. The additional government advocate accepts notice for the proposed impleading applicant. Application is allowed. Necessary amendment to be carried out. Now, what about 2 of 23?
Who is my amendment application? Sir?
No, 3 of 23.
It's a private party. We have no objection.
You appear. Are you free of? Who are you?
They are a contesting private party in respect of the
Land Council for the proposed including applicant submits. Civil suit is pending between the petitioner and the proposed including applicant. Taking note of the amendments made, said application is allowed. Including applicant is permitted to come on record as an additional respondent.
respondent number 5, my lord.
The amendment to be carried out cost item. Yes.
Serial number 55 is also connected. They may be connected together and the date may be fixed.
List along with serial number 55 and list in B group on
It may be fixed, my lord.
14.
Wait a minute. 55, my lord.
Yes.
Yeah, wait.
But there's nobody for the petitioner. Passover.
Hearing 44. Gautam Devsi, Atak Shetty.
And for respond number 1 and 2 in this matter, Malon.
When do you want it?
Next week, any date, Malon.
This is the matter.
Date may be
On 8th.
please.
Others, operations. Yes.
Six. 46. It's a matter where the officer reads the name of the petitioner and the predecessor's entitled after 80 years. But my lord was pleased to hear the matter, thereafter directed me to send the stop judgment which was filed on the last occasion.
Why was it adjourned?
But in fact, I think Leonard friend was not there. His colleague sought for an accommodation, but prior to that, my Leonard friend was there. So multiple times, adjournments have been taken for instruction.
But all other records are there. Correct. But now after 80 years, how you can say you doubt the grant? Not after 80 years. You have kept quiet so far. At each sale deed, you have been effecting mutations. You could have raised the objection at the time of effecting mutations in any of the previous sale deeds. Huh? That is by virtue of the order. That order is being tested now. Now, if 80 years back something went wrong, you have kept quiet all these years when sale deeds are executed, mutation is affected by you only. Yes.
And in fact, this question was discussed by your lords also in the 2020 decision. A cluster of judgments were decided by your lordship also on the question of delay. Raghavendra Murthy versus state and other connected matters.
Take me to the facts. Yes. There's one judgment by Justice Thakur,
That,
on delay in suo motu revision proceedings, wherein he has in detail dealt with the state's role while resorting to suo motu proceedings. That
in
is-
fact, this
Yes.
one particular point, my honorable raised just now, was dealt with by our High Court, the 2012 decision, where it says, may I just read out, I'll just pass it on. At para 7, it says, merely because the original records pertaining to the grant are not found with the Tahsildar, the entries made in the revenue records cannot be regarded as fraudulent entries and hence they had to be sent. Para 17, penultimate para. Para 17.
Yes.
Para 17.
You take me to the facts.
The present case.
Take me to a synopsis.
For the RAN survey number 103, was quoted as bar 4, bar 5, bar 6, and bar 7. In the proceedings of 1928-29, this was granted to one Venkatesh Iyer by the then Amaldar.
You take me to Annexure A.
Annexure A. Page 18. That is the proceedings of 1928-29, under which the grant was made. Type copy is at page 19.
Was made in favor of?
Favor of Venkatesh Iyer. GS Venkatesh Iyer.
Yes.
Thereafter, the entries were made in the revenue record of rights. That's at page 20, annexure B. It is ILR. And from 1969 onwards, the RTC extracts. 1969. The RTC extracts came into being. So from 1969 onwards, RTC extracts reflect the name of Venkatesh. I produced all the RTC extracts also. Annexure C. C poly is RTC extracts.
Yes.
Now, this Venkatesh Iyer, he dies in the year 2002. 27/11/2000, Venkatesh Iyer was leaving behind his children. The oldest being Vishwanath Iyer. Hence, the khata is made in the name of Vishwanath Iyer, his oldest son. Thereafter, my lord, in the year 2007, all the LRs join in and sell these scheduled property in favor of the petition. Thereafter, the petitioner's name is entered into the revenue records. That's in 2007, 1905-2007.
Page 90.
On 1905-2007. Annexure D. D. Page 82-91.
Mutation.
Mutation. The name of the petitioner. E. 92-94. Annexure E. Page 92-94.
5 of 7-8. MR 5 of 7-8. Yes.
Thereafter, the article extracts are also annexure F, 95, page 95, annexure F. Article extract and the name of the petition.
Yes.
Thereafter, the Tahsildars order is an annexure G, the 4-line order. The premise is, my lord, that some complaints have been received, and AC has directed the Tahsildar to take action under section 25 or 104. That is the first paragraph, page 96. Right.
Yes. You are not served with notice.
Since we are served, but we have not received any notice. But then we filed it before the AC, and then before the AC, we produced all our documents.
Read the AC's order.
Page 90. So we read the whole order. At page 98, the last part.
And what happened over the DC?
We affirm the same. Relevant portion is 101.
Yes. Yes. If it is the cancellation of a grant and the original grant was not in existence, then the power should have been exercised by the deputy commissioner, isn't it? Under section 25. So Tahsildar had no power if you look at it like that. Huh? No, I think land grant rules. Which one? Which provision? $25 off. Now the grant was made in 1920 by one not? Now for the first time IL was entered in which year? That IL document which you have produced. Now they admit that there is entry in that. So which year is that document pertaining? This appendix also they say it is there, though not authenticated. This appendix, like annexure A is there, though not authenticated is the finding. John? Before 19? Annexure?
he gave. From 64, 65 onward, that is his case.
So annexure,
Correction A. You know, it's annexure B, page 20. Right, copy it 21.
no, this is prior to 65. No, this is there in your records. ILRR is there. So even from, if you take 64, 2009, you initiate proceedings. More than 30, 40 years. Just put a flag afterwards on that ILR. And then mutation entries are there. And subsequent after the, including 2007. That is there in your records. The RTCs show the subnumbers. Yes, what are the authorities they're relying on? Yeah.
That 2001, then Tahsildar, she is given an endorsement or a acknowledgement by predecessors in typing. Yes, we have reference, not stress on this.
What is this document? Yeah. Vacant land or what? Vacant land or what is it?
Like what? It's a report I said there is some issue. The problem, now they go to 98 days. It's not, it's okay. It's size, it's the reline order. He gave indications as an institute order. After I'm not sure, can you see the document is I just reduced them. I just reduced them.
If at all, they had some doubt. Under 136.3, you must do it. Some DSS come and give complaint that that by itself sounds suspicious.
I just reduced them. Whomsoever it may concern, because of one document.
Doing a great disservice to Ambedkar by using his name directly and indirectly. Yes. What are the authorities you're relying on?
All of us. No.
Yes. Read the relevant paragraph.
What are the collection of education rights and public leading the next phase by the data exercise the power
Read.
As the member of Act provides for me, as three entries. In the letter of section 132 Act provides for
Which is the next. Which is the next authority? Read para 16. Paragraph? Yes.
power must be exercised within a reasonable time. By virtue of taking order taking process, 26, 5,050, it is declared that the land is that we have the land and the law, to reserve the public, further the consider as the land and the name of the condition is set out of this. As a other the name of all the conditions and it is back to the land. The remains by the Maharaja of except for a taking more of the details, Ramesh, outside the details. This is like cannot be economics. Making orders of us, probably necessary. The second position is about power. This is Anasai, just considering the piece, the division power. Technically, there is not need this. Rather, it's not the law, it's not the registry is not about the name. It's
Yes.
Last example was only this, there's still a it's not a this is today. The 2009,
Yes.
the last one, R17. Only graduates is here because the reports pertaining to the grant are not found in the person. Entries made in the revenue reports cannot be regarded as fraudulent entry. Hence, the act is
The petition. Now, only on the ground of delay, I will not enter into the merits. Apart from IL and RR, though even if you say it's before 1965, you have kept quiet, you have not initiated under 136(3). Sale deed is done in 2007. Mutation. The petitioner. But all the RTC's entries are there. from 1968. And that also, you have not taken any steps to cancel it if at all it is pursuant to a bogus ground. The petitioner has sought for. Just put a flag in the original records and have a look at it. The mutation entry of the petitioner has sought for issuance of writ in the nature of certiorari to quash the impugned orders of the Tahsildar dated 12/11/2010 in LND CR 15/2008-9 used at Annexure G, order in RA 266 of 2012-13 passed by the third respondent assistant commissioner, performing the order of the Tahsildar, and order in RA 60 of 2013-14 passed by the second respondent DC, performing the orders passed by the Tahsildar and Assistant Commissioner. The petitioner claims to be the owner of land having purchased property through sale deed dated 19/5/2007. From the children of G.S. Venkatesh Iyer. It is submitted that the sale deed at Annexure D has been executed with respect to the extent of 20 acres in its entirety, consisting of 5 acres in survey number 103/4, 5 acres in 103/5, 5 acres in 103/6, and 5 acres in 103/7 of Jammanahalli village, Avani Hogli, Mulbagal Taluk, Kolar district. It is submitted that the tracing of the title to the property would go back to 8/7/1931, when land bearing old number 103, new number survey number 103/4, 103/5, 103/6, and 103/7 was granted in favor of G.S. Venkatesh Iyer as per the proceeding evidenced by Appendix D produced at Annexure A, which observes the allotment of an extent of 29 an extent of 29 acres. Is it? No, what is the extent? Evidencing grant of land in survey number 103. It is submitted that subsequent to such grant, revenue records such as IL, RR, and RTCs were transferred into the name of Venkatesh Iyer, and reliance is placed on the extract of ILRR, which indicates the name of Venkatesh Iyer insofar as survey number 103/4, 103/5, 103/6, and 103/7 at serial numbers 164 to 167. It is submitted that thereafter, consequent to the demise of Venkatesh Iyer in 2002, his children having inherited their rights, mutation was effected in their names by virtue of MR 21 of 2006-7. That it is further submitted that the legal representatives of deceased Venkatesh Iyer together executed a sale deed on 19/5/2007, transferring the property to the petitioner, consequent to which MR 5 of 2007 was effected, reflecting the name of the petitioner in the RTC. Which was in the year, which was on 10/9/2007. Next. It is submitted that on 12/11/2010, Tahsildar initiated proceedings for cancellation finding that records relating to the grant and increase in the revenue records are concocted an order is passed by the Tahsildar on 12/11/2010. The same has been affirmed by the Assistant Commissioner, though the Assistant Commissioner records findings to the effect that Appendix D in Form 2 does refer to the grant, though the same is not authenticated. The Assistant Commissioner also observes that IL and RR with respect to the said survey numbers indicates name of Venkatesh Iyer as regards the above said survey numbers. It is further observed by the Assistant Commissioner that the sub numbers are shown as regards survey number 103. It is submitted that said order has been affirmed by the order of the Deputy Commissioner in a cryptic manner. Now, counsel for the petitioner, Sri Zulfikar Kumar Shafi, would submit that the grant proceedings relating to the year 1921 could not have been sought to be reopened by the Tahsildar as per the proceedings initiated in the year 2010. It is further submitted that consequent to the grant proceedings, there are entries made in ILRR which have been referred by the Assistant Commissioner, and such entries relating to the period prior to 1970. Same cannot be reopened in 2010 without any explanation for the undue delay. It's further submitted that the authorities have effected a mutation consequent to the death of Venkatesh Iyer in 2007. In 2000, in 2002, and Vide MR 21 of 2006-7, isn't it? Yes. And subsequently, after execution of the sale deed dated 19/5/2007, mutation MR 5 of 2007 came to be effected on 10/9/2007, and after having effected such mutation entries, Tahsildar could not have initiated proceedings at the instance of certain strangers who have no legal interest or title. It is submitted that the Assistant Commissioner has recorded findings which indicate that entries in ILRR are in fact found, and if that were to be so, there is no explanation forthcoming as to why the authorities kept quiet in light of the mutation entries as well as the RTC entries. Reliance is placed on the judgment of this court in Anna Rao and others versus Sri Gunda Reddy and others, ILR 1997, Karnataka 1998, for the proposition that power must be exercised within a reasonable period of time, comma, 2006-5 Karnataka Law Journal 131, S. Shivanna versus Special Tahsildar, Bangalore North Taluk, as regards the proposition that power must be exercised within a reasonable period of time, and as regards the same proposition, reliance is placed on the judgment in N. Raghavendra Murthy and others versus State of Karnataka 2028, Karnataka Law Journal 436. The petition also relies on order passed in WP 8933 of 2012 on the proposition that mere absence of original records pertaining to the grant would not result in regarding the revenue entries and records as being fraudulent. Third AGA would, however, submit that there is no evidence of OD proceedings, that the records indicate land to be Gomar land. And if the origin of title and if the grant records are themselves not genuine, no rights will flow to by subsequent transactions, and there are various factual discrepancies in the grant certificate relied on by the petitioner at Annexure A. He submitted that if entries are fraudulent, including the grant order, the subsequent title holders do not derive any title, and the land being vacant land, the aspect of delay ought not to defeat the rights of the state for restoration of the land. Heard both sides. At the outset, it must be noticed that what is sought to be reopened is as regards the grant stated to have been made in the year 1921. The first of the proceedings are initiated in LND CR 15 of 0809 at the instance of a third person, that is the convener, Dalita Samiti as well as Sri Kagiral Venkatesh, President of State President of the said organization. It must be noticed that if the proceedings were initiated in the year 2008-9, there is no explanation as regards the delay while noticing the ILRR pertaining to a period prior to 1970 contains the necessary entries, copy of which is produced at Annexure. You must listen. Annexure B. Annexure B. Full stop. It must be noticed this is for which year? Prior to? The original records have been produced by AGA. Which contains at page 31 entries in the ILRR, which would indicate that entries in serial number 164 to 167 stand in the name of Venkatesh Iyer as regards 103/4, 103/5, 103/6, and 103/7. This would full stop. As these records relate to prior to RTCs coming into force, that is prior to 1968, there is no explanation for action being taken to question the grant. Nevertheless, ILRR clearly has entries with respect to Venkatesh Iyer, even as verified from the original records. Subsequently, the RTCs have been entered in the name of Venkatesh Iyer from the year 1964-65. An entry is found in column number 9. Original record book containing the record of rights have been produced by the AGA, which would indicate entries continuing from 64-65 for the subnumbers of 103. Next, the petitioners, it is to be noticed that the RTC entries in the record of rights continues. ನಿಮ್ಮ ಆಸ್ತಿ ಇಲ್ಲೇ ನೋಡ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಟ್ಟು. It's all in tatters. I'll hereby verify. After this, I'll dictate and give it up back. I can tag after that. The entries continue till the year. Entries continue till the year.
2007 in the name of registration and this ಎಲ್ಲ 2007 onwards in the name of the petition up to 2010 when the order was formed.
We just make one small table, RTC, which page, which year, which subnumbers. Next. It is not in dispute that after the death of Venkatesh Iyer, mutation has been entered into the name of the legal representatives. MR 21 of 2006-7. Where do you find that page? In the RTC, there's a mention of it. Next, subsequently, after the execution of sale deed dated 19/5/2007, mutation is effected as MR 5 of 2007, copies of which are produced along with the petition. And entries are found with respect to 103/4, 103/6, 103/7. With respect to 5 acres each. And MR 21 And MR5 of 2007-8 has been effected. The said MR5 of 2007-8 finds a entry in column 10 with respect to the RTC for the year 2010-2011. There is no explanation regarding effecting of mutation consequent to the death of Venkatesh Iyer into the name of his children, and subsequently effecting of mutation consequent to the execution of sale deed by the children of Venkatesh Iyer in favor of the petitioner. If there was any doubt with respect to the origin of the grant, the authorities ought to have raised objection at the time of effecting mutation. Power must be exercised within a reasonable period of time, and clearly the initiation of proceedings are hopelessly barred by time. The order of the Tahsildar has initiated proceedings at the instance of third parties, and if there was any doubt regarding the genuineness of the grant, it was the government which was the custodian of such records that ought to have initiated proceedings. The Assistant Commissioner has acknowledged the existence of certain entries. The following para from the order could reveal the existence of such of the entries. Page 98, last part. Mere absence of grant records, which is however supported by other entries in the revenue records, cannot be held to be fraudulent. If the entries are made in the records, as is found in the present case in ILRR on perusal of the original records, it cannot be stated that the entries are fraudulent. The allegation in sum and substance is that the grant is fraudulent. That would not take away the legal effect of entries in existence right from 1960 onwards. The order of the Deputy Commissioner affirming the order of the Assistant Commissioner is cryptic. The aspect of delay has not been taken note of at all by the authorities. They are not advertised. Accordingly, the orders of the Tahsildar at annexure G, that of the Assistant Commissioner at annexure H, and that of the Deputy Commissioner at J are set aside. It is only expected that the state would give a burial to the proceedings, at least at this stage, rather than furthering the litigation, which on the face of it has no justifiable explanation of delay. Yes. The index of land. There is the original index of lands, which also indicates certain entries in the name of Venkatesh Iyer. Ask them to keep it. ಅದನ್ನ ಸೆಲೋಟೇಪ್ ಹಾಕಿ ಅದೇನಾದ್ರು ಮಾಡಿ ಪ್ಲಾಸ್ಟಿಕ್ ಕವರ್ ಇಡ್ಬೇಕು. ಇವಾಗಲೇ ಅರ್ಧೋಗಿರ್ತದೆ. At least till then it must survive. There is the record of rights with respect to 103/4, which records the name of Venkatesh Iyer in column 9. 10 for the years 95-96 to 2000-2001, comma, record of rights with respect to 103/5, which records the name of Venkatesh Iyer in column 9 for the year 95-96 to 2000-2001, comma, record of rights with respect to 103/6 from the year 95-96 to 2000-2001, which has the name of Venkatesh Iyer in column 9, and 103/7 for the years 95-96 to 2000-2001, which has the name of Venkatesh Iyer in column 9, as well as RTC with respect to 103/8 for 95-96 to 2000-2001, having the name of Venkatesh Iyer in column 9, as well as the RTC for 103/9. 103/8. Yeah. Similarly, the RTC in the book to 94-95 could reveal the entry of Venkatesh Iyer in column number 9, and also finds a mention of the sale transaction in column 10, and similar RTCs are found in the book produced by the AGA for 103/5, 103/6, 103/7, for the same years. We'll just take photos for reference. It is looking into the fragile nature of the records maintained. The respondent authorities are directed to ensure that the records are maintained till they are digitized eventually, and for that purpose, immediate steps to be taken to laminate the documents till eventual digitization is done, as is contemplated by the state authority. Is there some policy of digitizing these eventually. It is underway. It is underway. Yeah. But this must survive till then.
Restore my name, direction to restore my name.
Consequent to the order, consequent to setting aside of the orders of the Tahsildar, Assistant Commissioner and Deputy Commissioner, the authorities are to take steps to restore the names of the petitioners which were deleted consequent to the impugned orders. But till the case goes to the Supreme Court, the record must be made.
I'm very grateful to my friends, managed to get all the documents. Some cases are not that fortunate. Managed to get all the documents.
Yes. Take me through the facts. Yes. Yes, take me through it. Take me through the synopsis. Produced by the government. Page? Yes. Yes. It says yes. So the petitioner is Channa Keshavaya. Channa Keshavaya is the original. Yes. Page? Yes. This is 25. Survey number? Yes. Yes. You're reading at page 38.
Grant, favor of the delegation area, indicated selection or pay number 14. All the revenue documents are transferred in the name of delegation area, granting. Action or agree pay number 15. Pay number 15. This is the year 1960. Delegation area, we do not have any. Another one is cylinder 60, cylinder 60. Right side column is the around there. The other one is the next tower. This is the origin, respect of 75. There is second origin in the name of annexation. I will put in the name of annexation. Then you also put in my computer track. 14/1980. The first one number mother. One I purchased the entire extent of 10 acres of land in Daga number 25. P1 4/7/25. Of money. Yes, not over the regular. Relevant consideration. And the two minister areas. Which we have been granted. It was mainly fish management or by training. Even for the purchase of the land, there is one more land. Land is mutated in the name of one of my Burma. With my mother. Permission to do it. As per venture market, again, another resources that is not affected. Then this is another class. Then this is the or length, another again. Then second, there should be a letter.
Deputy Commissioner, when you would give permission to do this, what is the document? How will it be? What document is that? Only if it is how will it be not available? They know. Other is all documents are available.
Telecast also. Yes. What is missing now? What is missing?
University on 25 by 2012. One of the presentation given to the commissioner by this first one to effective 2012. When they were very effective 2012, let's make the restriction before the carnival. As for annexure B, the restriction.
Yes.
On inspection, the landlord government reason that is the option is taken. Not the bodies of the government. We consider the occupated goods. That's why they not identified this order. There was a space where there is recommend, but we need order. And actually, earlier there is already university completed 40 we consider they should not satisfy the order of the other thing.
You have not satisfied the new Tahsildar.
That's it. It is agency. It means the detective. Detective has access to 28. No. So that access to 28. The magistrate government. Number 30. Number 30. Data is written. There is a long time. The meaning is very criteria. Also, the launch of the service. After that, documents available in the don't. Then this is the revision. When number 33, revision also dismisses. There is a clear finding. All the papers may not be able to go further. This is a page number 33, paragraph 4. Open council appearing for the responders like a memory to one. Within the order dated, all the revision. In order of restriction by the government. The Deputy Commissioner examined the matter according to the ability of the revenue record. Person to alleged land in favor of generation. The mother of the petition. These areas that he held were order dated 15
entries have been made in the name of Chennai case. Yes, sir, added grant. Yes, but yes, that the order of the regular order equally. The 19 question was granted in favor of Chennai case as a fact. As in the year 1960. I think subsequently identified 19 questions for the 1980. The mutation was affected in the name. The mutation was affected in the inheritance name of the family. The Deputy Commission has a lot of support. Initially under the Land Revenue Act, in the land. Now, this is clear the contention taken by the registration. The order of water the registration of water into disclosing two major factors. Suppressing the them of suppress the land. Made in view of the winter of the creation and more substantive. Thank you. This is not identity. Then the question is the meaning. What I the maybe there should be order. What they have done in before pay number, actually pay number 18. Background should be one thing again. Actually pay number 18.
What are these other previous just arguments?
Argument, the argument and all the documents, all the documents. Come to the conclusion because the document, whatever they are thinking of. In the instant case, we have a very issue for consideration or issue. Whether the land is available to 55 gold and 55 but I'm looking into the notice to one go.
about 25. Then Chennai has been granted it to you not the about 50. It's a 25. The government has given. All the states, all the states, and position has not been granted in the generation. However, the land has been allocated in the I did the opposition. The decision reported earlier in and bogus. They're all basically all the land in question was granted instead of the land right as in the land in question. This is also in our name. Other reminder is the saving for the economy has created money. Then on the other phone, upon understanding should be the commissioner directed to but no such limitation. Not necessarily not question for the Deputy Commissioner is backpeding letter. Section 136. The Deputy Commissioner after failure of the whole process, there is even a pending.
Land was granted in the name of annexation, where in the reservation. And that grant is not over. No electricity, no power, no there is no even for the sake of argument, no power to use it. Deputy Commissioner, by launching a proceeding,
Now that all that proceeding has dropped, there ends the matter. 136 proceedings have been dropped. Right? They have to point out what is wrong in that order.
Yeah. The revenue numbers are more difficult for this. And the rates of police, correct police.
This one. We'll continue. Tomorrow I'm not sure, but I'll be in the list tomorrow. Let us have some parted matters and bench. But since I've already heard, I'll repeat it till we conclude. ಇನ್ನು ರೋಸ್ಟರ್ ಇನ್ನು ದೂರ ಇದೆ. It's the matter for further hearing tomorrow. How much more time you'll take? In your synopsis, correct. Just put the page number of the annexures in this only. This only. Here only you have mentioned. You put in the margin page numbers of R2, R4. Pencil marking ಮಾಡಿರ್ತೀವಿ ಇದರಲ್ಲೇ ಬರ್ತೀವಿ ಅಲ್ಲ ಇದರಲ್ಲೇ ಮಾಡ್ತೀವಿ. Other matters, you can take dates from the court officer, depending on whatever time slot is available.
Serial number 61, my lord.
My lord, Monday, my lord.
Dates, the court officer will give him a free hand, depending on whatever time slot is there. He'll give it to you. Are they told?
Serial number 61, sir.
Yeah. Monday. ಒಂದು ನಿಮಿಷ ಸರ್ ಯಾವ್ದು ಖಾಲಿ ಇರುತ್ತೆ ನೋಡ್ಕೊಂಡು 49 4th to 7th 49 79 ಸರ್ 40 50 ಸರ್ 50 ಇದೆ ಸರ್ 7 8 50 ಇಲ್ಲ ಆಯ್ತು 52
ಅದು 70
53 Monday Tuesday 54 ಬೇಡ ಸರ್ 8
entry model consider.
After 11th, 11th, 12th.
61, sir.
59 ಬಂದು 12th.
23 matter ಅಲ್ಲ
61.
23 matter ಅಲ್ಲ
ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ 53. ಯಾವ್ದು ಹೇಳಿ? 8 ಬೇರೆ ದಿನ ರೀಚ್ ಆಗಲ್ಲ, ಶುಕ್ರವಾರ ಬೆಳಗ್ಗೆ. ಅದಕ್ಕೆ ಬೇಡ ಅಂದ್ರೆ ಬೇರೆ ದಿನ ಆಗ್ತದೆ, ಸೋಮವಾರ ಆಗ್ತದೆ. ಹೋಲ್ಡ್ ಮಾಡಿದ್ದು ಅದು 59, 11/9, 64, 11/9, 65, 12/9, 230, 12/9,
61, sir.
6, 7, 6 ರಜೆ ಇರುತ್ತೆ, ಬರಲ್ಲ. 7 ಜಾಸ್ತಿ, 45, 80 ಮ್ಯಾಚ್ ಇದೆ. 8, 90 ಮ್ಯಾಚ್ ಇದೆ. 11th 13 ಇದೆ, ಖಾಲಿ ಇದೆ. ಅದು ರೀಚ್ ಆದ್ರೆ ಮುಗಿದು 67 ಅದು 13. ಎಂಟ್ರಿ ಮಾಡ್ತಾನೆ.
along with the connected matter. Along with 42 dates. 42
Sir, 61.
ಒಂದು ನಿಮಿಷ ಮೇಡಮ್. 61 ಅಲ್ಲ ನಿಮ್ದು? 61 ಅಲ್ಲ? 12/9 ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ, ಬೇಡ ಅದು ಜಲ್ದಿ ಕೊಡೋಣ. ಡಿಸ್ಪೋಸಲ್ ಅಲ್ವಾ ಅದು?
ಹಾ ಸರ್.
ರಾಮನಗರ.
ನಾಳೆಗೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್.
ನಾಳೆ ಇಲ್ಲ, ನಾಳೆ ಕನೆಕ್ಟರ್ ಮ್ಯಾಟರ್ ಬರ್ತಾ ಇದೆಯಾ? ನಾಳೆಗೆ 19 61 ನಾಳೆ
connected matter. ರಾಮನಗರ ಅಲ್ಲ ಬಿಡ್ದಿ.
ಇದೆ ರಾಮನಗರ. ಅದ್ರ ಮೇಲೆ
ಅದ್ ನೋಡಿ ಅದ್ ಕೊಡಿ.
ಗೀತಾ ಅವ್ರದ್ದು ಒಂದು ಸುಮಾರು ಮ್ಯಾಟ್ರ್ ಇದಾವೆ ನಾಳೆ ಡಿಸ್ಪೋಸಲ್ ಆಗುತ್ತೆ. 10 ಮ್ಯಾಟ್ರ್ ಇದೆ ಯಾವುದು?
ಯಾವ ಡೇಟ್, ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್? ಸೀರಿಯಲ್ ನಂಬರ್ 12/9 ಕೊಟ್ಟಿದಾರಲ್ಲ. 9 ರಜಾ. ಸೀರಿಯಲ್ ನಂಬರ್ 68 ಬೇಕಂತ ಕೊಡ್ಲಾ?
ಕೊಟ್ಮೇಲೆ ನನಗೆ ಹೇಳ್ಬೇಕು.
ಸೀರಿಯಲ್ ನಂಬರ್ 68.
ಅದೇ ಪಾರ್ಟ್ ಮಾಡ್ತಾರೆ.
Sir, body causes to please. Manju, sir, please. ಏನ್ ಮಾಡ್ಲಿ?
ಅದೆಲ್ಲ ಕಳ್ಸ್ಬಿಡೋದು. ಅದೇ ಅದಕ್ಕೆ ಕಳ್ಸ್ಬಿಡೋದು. ಅದು ಗೌರ್ಮೆಂಟ್ ಅವ್ರು ಸೆಪರೇಟ್ ಕೊಟ್ಟಿದ್ದು ಮೇಡಮ್. 2 ಮಾತ್ರ ಮೇಲ್ಗಡೆ ಪಿಟಿಷನ್ ಅದು ಸೆಪರೇಟ್, ಇವೆರಡು ಗೌರ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದು. 2 ಮಿಕ್ಸ್ ಆಗ್ಬಿಟ್ರೆ ಅದು ಸೆಪರೇಟ್ ಇಸ್ ಸೆಪರೇಟ್. ಅವೆರಡು ಒಂದು ಸೆಪರೇಟ್. ಕೈಯಲ್ಲಿ ಬರ್ದಿರೋ ಸೆಪರೇಟ್. ಕೈಯಲ್ಲಿ ಬರ್ದಿರೋ ಸೆಪರೇಟ್.
14/9.